All rise. The President and judges of the Supreme Court of the
call the matter.
CCJ application number AL6 of 2006, Tyrone Da Costa Cadogan versus the Queen.
Repeat, Your Honours, in this application I appear for the applicant, and with me is Tarek R.
Thank you.
Please, Your Honours, in this matter I appear for the respondent, and with me is my learned friend, Mr. Roy Hurley.
Thank you. Yes, sir, Mr. Shepherd, would you come to the lectern?
Thank you, Your Honour. Your Honours, just a housekeeping matter first of all. There was an amended notice of application which was filed on the 28th of September 2006. And with that amended draft was a take notice of our intention to seek leave of this court to amend the notice of application. And I would make that application at this stage. I think I spoke to the learned director of public prosecutions this morning, and he has said to me that he has no objections to that application.
He has no objection to the amendments. Is that right, Mr. Legal?
Indeed, Your Lord.
Yes, well, we only had sight of that application yesterday, Mr. Shepherd. It's unfortunate that it was filed as late as it was. It was filed, I gather, at about 3 o'clock in Barbados on Thursday. And that was just 2 working days before the... I don't know what the reason is why it was filed so late. But we really I expect that council will be more considerate of the court, and give us the opportunity to read and digest matters that you are going to be arguing before us.
Your Honour, I first of all must apologise for the tardiness, and I accept Your Honour's position in relation to the lateness of filing. The difficulties arose in this case, Your Honour, because I was obviously not counsel for your applicant at the High Court or the Court of Appeal. And Your Honours will realise that in the application we seek to take issue with the conduct of the defence by his counsel. When I went to the cases, it became very clear to me that in order to take that point, I ought to consult with the attorney, Dr. Ramsey, who appeared for your applicant in the High Court and the Court of Appeal. What had happened in that case was that I took instructions from the client. I then spoke to Dr. Ramsey. I reduced my conversation with Dr. Ramsey into writing and sent it to him, but he was away for the week and I could not get his response. When he returned, he gave me additional instructions which necessitated me taking further instructions from the client, and then
Who gave you further instructions, Dr. Ramsey?
I'm sorry, my lord.
Are you saying Dr. Ramsey gave you instructions?
He advised me as to what had occurred during the course of the trial. and it was that toing and froing that caused the difficulties in relation to the preparation of the amended application. Your Honor,
Dr. Ramsey appeared for the accused, did he?
he did, Your Honor, in the High Court and the Court of Appeal. And given what Dr. Ramsey said to me on the first occasion, I became very, very concerned about the conduct of the defense. Your Honor, if I can, I think I have agonized over this to some extent, and we will come to it in due course. But I have come to the conclusion that there is very little left but for me to place before the court exactly what my instructions are and what Dr. Ramsey revealed to me. Essentially, Dr. Ramsey used the word tutored when he first spoke to me.
Use the word what?
Tutored.
Shooter.
Tutored. T-U-T. Tutored the client. Your Honor will recognize that there was a difference between the written statement of this accused and his evidence on oath.
I don't want you to argue it out of turn. We were merely on the lateness of the amendments.
I'm grateful to Your Honor.
And, I don't want to belabor the point, but you and I think your junior have filed the initial application, which I think was around the end of June, I think.
July.
July.
Yes, it was the 25th of July.
Yes. So, one would have hoped that, anyway, that we would have, you would have had the time to research whatever had to be researched before. However, there is no objection, yes. The amendment will be granted, is granted, Mr. Shepherd.
I'm grateful to Your Honors, and I do accept Your Honor, Right Honourable Lavisse's strictures or reprimand. I think it is justified in circumstances. Your Honor, in my submission, there are 4 essential points which address first of all the question of our complaint in relation to the trial judge's direction on intent. There is then the question of counsel error, the right to facilities, and the question of diminished responsibility. In relation to the test, Your Honors, I had in fact obtained from the site the decision of this court in relation to the Merchandani case, in which this court had reason to address the question of what it would apply in terms of granting leave. And I could not help but notice that during the course of delivering that decision, Your Honours made mention of Section 8 of the Caribbean Court of Justice Act. I will obtain a copy of the decision for Your Honours, but it is my submission that Your Honours were of the view that applications for leave to appeal in criminal matters are properly brought under Section 8 of that Act. No doubt Your Honours are aware that prior to coming into force of the Caribbean Court of Justice Act, the position was that in all criminal matters one required leave of the Judicial Committee of the Privy Council, which was a sort of screening process. And as far as I'm aware, those applications were decided on arguability. I do note that in the Merchandani case, the court made reference to a test that referred to whether it was arguable that a miscarriage of justice, or there was a likelihood that a miscarriage of justice may have occurred. But the court did, I think, in that case, take the opportunity to say that it didn't want to lay down any general rules, but would deal with each case on its own merits. But as I say, we've asked for the copies of that decision. I'll make it available to Your Honours at a later stage. Now, if I may, with that opening, just proceed to the question of the directional intent. No doubt Your Honours are aware that the Court of Appeal dealt with this at page 31, which is tab 5 of the volume containing the notice of application, where at page 31 the court set out what it regarded to be certain propositions. And that is at pages 31 to 32. Having set out those propositions, the court said at page 33, and that is paragraph 42, we have serious reservations that this was a case where a direction about virtual certainty within the terms of Vedrick and Woolen formulations ought to have been given simply because the appellant said that he set out to rob the deceased. We think that rightly such an argument was not canvassed before us, because to have done so would have been to fly in the face of common sense and elevate the appellant's statement of his purpose beyond the compelling inferences from the overwhelming factual circumstances pointing in a contrary direction to the appellant's assertion. Now, Your Honours, as I said, I did not appear for your applicant at the Court of Appeal, but the grounds of appeal are in fact set out at tab 6. The fourth page of tab 6, which is the Form 1 Criminal Appeal Act. And down at the bottom of that, your lordships will see grounds of appeal or application. The verdict was unsafe and unsatisfactory following Maloney. A verdict of manslaughter should have been substituted for one of murder.
What page of the record?
That is tab 6, Your Honour.
Of the record?
Of the record which contains the notice of application originally filed on the 25th.
Not mine.
It is on your lordship's screen. I'm sorry, Your Honour, it is not there in tab 6.
Yes.
Not mine. No, I have it on the screen.
Okay. Go ahead.
I had some difficulty with that, my lords, because, well, in putting it this way, as I understood the defense, it was simply that the accused did not have the necessary intent at the time. And so I can't understand why it would not have been argued, if one is referring to Maloney in the grounds, that that direction ought not to have been given. Now, Your Honours, it is my submission that that direction ought to have been given. And I so submit for these reasons. First of all, Your Honours, I think it's helpful to look at the direction itself. And that, I think, has been perfected in the case of Woolen. That is in Volume 1 at tab 15.
Mr. Shepherd, perhaps if it would help if I gave general indication that this being the application for leave, we would not expect that there would be any lengthy referrals or multiple referrals to authorities. I think that we would like as far as possible to receive the argument in fairly compressed form so that we can then rule on whether to grant special leave or not. And of course, if leave is granted, then we will return on another day to hear your arguments more fully.
Well, Your Honour, if I approach it in this way then, and without taking Your Honours to the authorities, I think I can put the point very simply in this way.
I'd be very much obliged, Mr. Sherwood.
Thank you, Your Honour. The will and direction is simply, as I understand it, Your Honours, that the jury are told that they're not entitled to find the necessary intention unless they feel sure that death or serious bodily harm was a virtual certainty as a result of the defendant's actions and that the defendant appreciated that such was the case. Now, in my submission, it seems unclear, or the categories of cases where that direction is needed is to some extent unclear. It is my submission that the categories of cases are said to be, and I refer to Hancock, Lord Lane, at page 459 and 461, in cases where the defendant's motive or purpose was not primarily to kill or injure. And according to Lord Scarman in Hancock at page 474, in all cases where foresight of a consequence is part of the evidence supporting a prosecution submission that the accused intended the consequence. And according to Lord Bridge in Maloney at 926, where he does describe it as rare, where given the way in which the case is presented, it is necessary to direct the jury in terms of foresight. So, and I would just like to draw your Lordship's attention to the fact that Lord Scarman in Hancock had some doubt as to whether the cases would be rare or not. The point being, as I understand it, my lords, that in cases where the defendant's motive was not to kill, or in cases where, given the manner in which the case was presented, the judge thinks it's necessary to direct the jury in those terms. Now, unfortunately, Your Honours, we do not have a transcript of the addresses of counsel. And I do not understand that. There is simply there's nothing in the record to reveal what counsel said in their addresses to the jury. Now, there is, however, in the summation, an indication, at page 210 of the summation, at line 15, the defense's case is that you must not come to a conclusion on what the accused intended based on the gruesomeness of the crime. Dr. Ramsey told you that intent must be distinguished from foresight of consequences, and that the evidence shows that he had no intention to kill or cause serious bodily harm to Paulette Brathwaite. And at page 209, I'm sorry, Your Honour, at line 18, there is a reference there to the speech of the Director of Public Prosecutions. They also rely on the injuries inflicted on the deceased as detailed in the evidence of Dr. Stephen Jones where they were inflicted and the weapon used. So there was a reliance, it would appear, on the extent of the injuries, and we have Dr. Ramsey's suggestion that there should be that the jury should distinguish between foresight of consequences and intent. Your Honours, I did make an attempt to try and get from Dr. Ramsey any notes that were available of his speech. I asked Dr. Ramsey for his file, and I have not received it. I am under the impression that Dr. Ramsey appeared on his own and he took no notes. I also asked of the Director of Public Prosecutions whether there were any notes of the addresses. And he will give you his response in due course, but my understanding is...
Why are they so crucial?
Because
the address is so crucial.
Well, my Lord, for, I think, two reasons. First of all, on the question of intent, if the director or if the counsel for the Crown said to the jury, there were 18 stab wounds here, the crime was gruesome, it was a horrible, horrible thing, and therefore, as you know, this accused actually committed those acts, then he must have intended to kill.
Yes.
Now, once those words must have intended to kill, if they were ever used, to my mind, then it would bring the case firmly within the suggestion that Lord Bridge said, wherein which the case is presented, it is necessary.
But, I'm not sure that I follow why. If someone puts a gun to another person's head and pulls the trigger and blows their brains out, is that going to attract the need for this foresight direction?
I would have to answer that question no, because it appears to me that their lordships in Maloney were concluding that it was a case in which one would give the simple normal directions on intent, and that the trial judge erred in going to this question of foresight.
But isn't that basically what the Chief Justice was saying about this case, and that given the actions of the accused, they were getting to the level of the situation I've described, where it was obvious that anyone, if not an attack with a knife of that sort, would have the result which occurred. And I thought that the case for the accused was that the effect of the alcohol and the marijuana was such that it negatived the inference which would normally be drawn from his action with regard to the existence of an intention. And therefore the whole thing turned on whether the jury accepted that had been the effect of the drugs and of the marijuana and the alcohol was to prevent the creation of this intent.
Yes. I accept what Your Honor is saying, and I would answer Your Honor in this way. The defense was, essentially, as I understand it, that he was so drunk he could not form the necessary intent to kill or to do grievous bodily harm. Assuming that the jury rejected that, my difficulty occurs because if in rejecting that defense, the jury deliberated along the lines that, given the severity of the attack, he must have intended to kill, then a miscarriage would have occurred. What is certain, Your Honor, I think, is that the legal position is that you cannot conclude that someone has an intention to kill or do grievous bodily harm based on an inference that the severity of the wounds would naturally give.
Where is the authority for that proposition?
Well, now, Your Honor, if I can take you now to that, I think, is, first of all, in Maloney, which is at tab 11. And the direction.
But isn't Maloney really replaced now in terms of authority by Woolen?
It is, Your Honor.
So why are we looking at...
Well, because in my submission, Woolen refines the direction that you give in order to address the problems in relation to foresight and intent and all the rest of it. But insofar as Maloney spoke to the necessity of a direction in certain circumstances, in other words, the circumstances in which the direction would be given, I think it is still good law. And if I can take Your Lordship...
Briefly, the facts at Maloney, if you can just...
The facts were that they were drinking, and the stepfather and the son were in the drawing room or whatever it was. They were very drunk, and the stepfather said to the son, "I bet you I can outdraw you," or something like that. The son goes upstairs, gets the two rifles, brings it down. They sit in front of the fire, and they're loading the guns, and the son picks up the gun, points it at his stepfather, and pulls the trigger. That is why, Your Honor, I agreed with you in terms of the direct attack in Maloney. Later on, I think, in the other cases, it is suggested that the trial judge erred in Maloney because he should have given just the simple direction that judges normally give on intent and not go to the whole question of foresight. But Your Honor asked me for authority for the submission that I made that in this way, that it is not open to a jury to find that an accused intended to kill or to do grievous bodily harm based on based on an analysis of the injuries. In other words, the injuries are so severe that he must have intended it.
But surely, Mr. Shepherd, this is only in the context of what occurred before the injuries were sustained. In other words, in the case of Maloney, there was never any indication that the son wanted to do harm of any kind to his stepfather. The circumstances in this case, in the instant case, are very different. And therefore, wouldn't those circumstances carry this case right outside of the proposition which you are advancing in Maloney?
Depending on the manner in which the case was conducted.
I don't I think it depends on the facts, not on the way in which the case is conducted. You have now said that the inference cannot be based on the injury. But that may well be so. But here we are not just left with the injury alone. The evidence is of the attack which produced the injury.
Perhaps I can enlarge.
That seems to me to be a different thing from inferring it simply from the injury.
Yes,
Somebody attacks somebody else with a knife and inflicts a number of wounds and slits the person's throat. Are you seriously going to suggest, in the absence of some such factor, like drugs or alcohol, that you can't infer an intent to do grievous bodily harm from that evidence?
no, I am not suggesting that, Your Honor. I am suggesting, however, and if I can take Your Honor very quickly to page 919, letter B of Maloney.
Yes.
It will be observed that in this passage, foresight of probable consequences as an alternative to intent has become mere foresight. The Crown's case of what it was contended the appellant must have known is recapitulated at some length. Now, we struck out on this, Your Honors, because Your Honor asked me what would be the importance of the addresses. If the learned director said to the jury, given the injuries, the extent of the injuries in this case, the accused must have intended to kill or do grievous bodily harm. Is this not a case which falls within the category of cases that are described by Lane in Hancock and Lord Scarman?
Yes, all right.
And that is my simple point, my Lord.
Could I broaden this, Mr. Shepherd? We have to look, I think, beyond the pure injuries inflicted. It appears that it is well open to the jury to find that the accused knew what he was doing. He decided to go and rob someone. He hid behind a hut. He kept out of the way of the policeman. He then followed two policemen to make sure the coast was clear. The attack then occurred, but he stopped when he heard a police car coming nearby. He then escaped via a particular route and through a hole in the fence and so on. So he seemed to know what he was doing. And what happened in the middle was, remember, it was a butcher's knife with 22 centimeters, which is this long. So it's that long. And he stabs her 16 times. Now, I would have thought it's open to a jury to find that he was compos mentis enough to know what he was doing before and afterwards, and therefore what the consequences were, what he was doing when he stuck the knife in 16 times up to the hilted time.
I would add one other factor to Your Honour's list, and that is the coherent statements to the police as well. So when you look at all of that, yes, to answer Your Honour, yes, it was open to them, but I think that is an argument for the application of the proviso. In other words, Your Honours, let us assume that was the way in which the case was presented by the Crown. Let us presume that the Crown said, given those injuries, you must have intended. And let us assume that the jury could have dealt with it in that way. That, look, forget about all that. 16 stab wounds, he must have intended guilty. Then it's a question of applying the proviso. But there is still, in my submission, an error in the trial judge not addressing that question and simply warning the jury in terms of the Woolin direction.
What is the direction of the trial judge of which you complain?
He does not deal with it at all, and the direction is set out Your Honor, at page, in the decision of the Court of Appeal, at page 31. Oh, I'm sorry, no, at page 33.
That's, what tab is that?
And that, sorry, Your Honor, tab 5.
That's right.
I think it's helpful, Your Honors, to refer back to what has been regarded as the willing direction, what I call the willing direction. It simply says that it's a direction that the jury are not entitled to find the necessary intent unless they feel sure that death or serious bodily harm was a virtual certainty as a result of the defendant's actions, and that the defendant appreciated that such was the case. So the simple point is that you cannot simply infer, as I understand it, malice aforethought from the physical injuries unless you are sure that death was a virtual certainty, which I don't think there can be any argument on in this case, but also that the defendant appreciated that as he was drunk.
Yes.
And we are here talking about drunkenness, as I understand it in the past, being a negativing of intent. In my submission, therefore, it is simply arguable that the willing direction ought to have been given in the circumstances. And that, I think, may be underscored by the manner in which the case was presented and defended at trial. Unless there's anything further, Your Lordship, Your Honours,
I think that's so. We've got the gist of it.
I will now pass on to the question of counsel error. Your Honour, what happened at the trial was that the statement was allowed in without any objection. And then the accused took the stand and gave evidence that can only be described as being in contradiction to his statement. Now,
what was the objection that should have been taken?
That the statement was not, in fact, his statement.
Was not given.
Was not given, yes, Your Honour.
But that would not found an objection, would it?
Yes, Your Honour. It would found an objection in terms of a voir dire, which, of course, Your Honour, could be raised. Yes, we do. I think the position in Barbados is that even in those circumstances, we do a voir dire. The learning director will correct me if I'm wrong.
Can you refer us to it, to that provision?
The provision that necessitates the voir dire?
When the objection is not...
Oh, not taken.
Not to the voluntary...
Yes, that is first... It is first...
Understanding that it was not made at all.
It wasn't. In any event, while I'm finding that, Your Honour, it is certainly, even if one didn't object to the statement at that time, one would be expected to put to the police officers in the presence of the jury that the statement was not the statement of the accused.
Yes.
Now, I think that is to be found, first of all, at page 40. I'm sorry, of tab 6, Your Honor. And it starts with, at line 22, by cautioning him, what did you say to him? You are not obliged to say anything unless you wish to do so, and whatever you say will be taken in writing and given in evidence. And then across the page, question. Just a minute, page 41. Just a minute, officer. Mr. Leacock. At this point, Dr. Ramsey, in light of the evidence, is there anything you wish to say to the court? Dr. Ramsey, I have no objections to the oral. Mr. Leacock, you have no objections to the oral. That's the indication. The court, let's get it right. He is about to make a reference to the second oral in the depositions. Mr. Leacock, he is well aware of it, the court, and there is no objection from you, Dr. Ramsey. No, sir, no objection. Thank you very much. Let's get the record right. And then, page 42, at line 10, the accused then dictated a statement to me which the court, Dr. Ramsey, no objection to the statement. Dr. Ramsey, you said you have no objection to it. Dr. Ramsey, no, sir. The court, he's about to make mention of the written statement, and you said you had no objection to that? No, sir. All right, thank you very much. I just wanted to get the record right.
Well, Mr. Shepherd, I'd be grateful if you could refer us to the provision in Barbados, which requires a voir dire to be held if the accused denies making the statement.
Your Honor,
as opposed to challenging its voluntariness.
Yes, okay. Your Honor, I will find that authority for you. I will. I know that in the past, when we go far back, there was always a position that there was no necessity to hold a voir dire when it was simply a straightforward question of fact.
That's what the Joda says. Joda makes that point very clearly. Privy Council case of a Joda.
Absolutely, Your Honor, but it is my understanding that it certainly was the practice to hold a voir dire even in those circumstances.
For a Joda?
After.
I don't think so, Mr. Shepherd. I'm not aware of that at all.
Well, Your Honor, can I get back to you on that? But can I just say this? Certainly, there was never any position stated by counsel to the police officers that there was any objection to the statement or its contents. So even if one is correct in terms of the voir dire, certainly if your case is that the accused did not make the statement, it was essential that you actually cross-examined the police officers in those circumstances and put that to them.
But did the accused give evidence that he had not made the statement?
He gave evidence, that is at page... I think it's at page 124 and on.
But what he says there is that they wrote the statement and he signed it, isn't that?
Yes. No, he said he didn't write it, that...
They wrote it.
They wrote it.
Yes.
And certainly he said that... That's at page 126, Your Honor, again in tab 6. Didn't you tell the police at line 16? Didn't you tell the police that she is one of the Golden Girls? No, sir. Didn't you give a written statement to the police? I did not write a statement, sir. Didn't you dictate a statement to the police and you signed it? Answer, I did not give them a statement, sir. Did you hear the police sergeant Greenwich here saying from the stand yesterday that you dictated a statement to him which you signed and wrote the certificate on? Yes, sir. Very well. Did you hear the statement read? Yes, sir. And then he admits
have you got anything from Dr. Ramsey as to what his instructions were on this?
In brief, Your Honor.
Yes.
If I can take you through this chronologically. First of all, my instructions were that Dr. Ramsey never saw the accused in private, ever, other than at the CID. Those are my instructions. When he had been arrested and after he had given his statement and prior to going to court. My instructions were that after that, he went to Glendairy to see another prisoner, and the accused asked to see him, and he saw him for a brief time in the presence of another prisoner. And that apart from that, the only time he saw Dr. Ramsey was in court. And that he had never given to Dr. Ramsey any instructions written. Certainly there was no statement taken from him. Dr. Ramsey said to me that he had seen the prisoner at Harrison's Point prior to the trial. My instructions were that that never occurred. And when I asked for records of visits to the prison, I was told firstly that there would be a difficulty in getting visits to the prison prior to the fire, because they don't know where they are, even though it may be possible to get them. And I asked to see records of visits to Harrison Point, because the evidence suggests that the accused was there for about 2 or 3 weeks prior to his trial. I was told that by one of the prison officers that there is no record of any visit from Dr. Ramsey during that time.
Is there no record, or the records have been destroyed?
There's no record at Harrison Point. That's the new prison.
Yeah.
Because the fire occurred prior to the trial. And after the fire, I think he went to St. Philip, one of the interim stations, and then after that he went up to Harrison Point for a period of about 3 weeks, as I recall. But the Harrison Point records, according to the authorities, do not reveal any visit from Dr. Ramsey.
But are there records of visits?
Yes,
by
Your Honor.
counsel to,
Yes, we have to sign in.
Sorry?
We have to sign in. And at the old prison, when you came to the gate, you declared who you were, and they made a note. At the new prison, you declare who you are, they sign you in, and then you sign yourself out. So there are always records of visits to the prison. Now, Your Honor, this is, Your Honor...
But, Mr. Shepherd, are we going to be expected to act on the basis of what you tell us about what the Dr. Ramsey says and what the applicant says he did or didn't do?
Well,
is that the basis on which you are going to ask us to act? In action, we have something in writing from Dr. Ramsey dealing with the matters on which you are wishing to criticize him?
Absolutely.
Well, where is it?
All right. Now, Your Honor, if I can take you through that. Your Honors are no doubt aware of the Sankar case and the cases to which we refer in the bundles. There's a Sankar case out of Trinidad, and that is at tab.
What is this you're passing up if I may?
Now, I was taking your, before you hand it up, I was taking your honors. I was hoping to take your honors through the exchange of correspondence between myself and Dr. Ramsey.
Mr. Shepherd, this is most irregular.
Your Honor,
Do appreciate that visa should have been filed in advance of today's hearing.
Your Honor, yes.
Don't you think that the other side are entitled to see it and have a chance to consider it?
Your Honor, if I can explain my tardiness and the way in which I handled it in this way. Given my initial conversation with Dr. Ramsey, I was very concerned about Dr. Ramsey's position. And I simply did not know what I should do. In the end, I decided to put Dr. Ramsey on notice that I would reveal, even though I wasn't sure whether I was going to, the correspondence between himself and myself. But I also, in that letter, advised Dr. Ramsey to take separate legal advice.
Well, I don't know, but I don't think we can allow it to be done in this way.
In any event, Mr. Shepherd, the council can't make bricks without straw, and if we assume that council should have asked a couple of questions, the one about whether he recognized the deceased as a golden pussy girl, and the other one whether it was his idea to rob or his mate's idea to rob, it doesn't affect the rest of the statement and the oral evidence that was given by the accused, whereby he admitted he was lurking by the plywood, he watched the police go, he followed them, he went to the alley, it wasn't that dark, when a police car came, he did a runner, got the shortcut back to the shop, and so on.
Well, I have one other comment to make on that. It has been my experience at the bar that if counsel does not put to a witness something as elementary as not giving a statement, there is generally an invitation, and it's accepted as being quite proper by the Crown to find that the accused is not telling the truth because he never informed his counsel of those matters and changed his mind on the witness stand in comparison to what he told counsel.
And of course, another possibility is that the accused was not telling the truth
On the stand.
in cross-examination. When he was under pressure by having his attention drawn to discrepancies in his evidence as compared with his statement, he took refuge in desperation in the story he then gave.
Except, Your Honor.
I mean, why didn't he, for instance, when assuming that he was not asked about it before, when he heard the evidence given about the statement in court, and he heard the statement read, would he not have told his counsel on his own initiative, look, I never gave that statement?
One would have expected that, Your Honor, but at the same time, given my initial now we are now getting into the conversations with Dr. Ramsey. First of all, Your Honours, it is my understanding, given the conversations with Dr. Ramsey, that certainly no written instructions were taken.
But, Mr. Shepherd, I think if you are going to say that Dr. Ramsey should have cross-examined in a certain way, we would need to get from Dr. Ramsey what his instructions were, not simply what you say his instructions. He told you his instructions were. It all depends on what his instructions were. And it's quite likely, as the President said, that under pressure in cross-examination, the accused decided that he had to give a different
Those
story.
were not my instructions from the accused, or in fact from Dr. Ramsey.
But you don't get instructions from Dr. Ramsey.
So sorry, my information.
And that's precisely the problem.
Your Honours, where do we go from here? Let us assume for one moment that there is an interpretation of these facts that is at least arguable, that the case was somehow not properly presented and that affected the result. One interpretation of the facts is that. Another interpretation of the facts may be that that is not the case. And precisely as the President has indicated, that Dr. Ramsey had proper instructions, conducted the case in light of those instructions, and then was completely surprised at what the witness said on the witness stand. There is, in fact, before Your Honours, an affidavit of the applicant. And that affidavit, Dr. Ramsey is aware of its contents. Essentially, what is counsel to do in these circumstances? And this is how I proceeded. I took instructions. I put those instructions to Dr. Ramsey, including a draft of everything. Dr. Ramsey came back to me. And when he came back to me, I was surprised at what Dr. Ramsey said. I then went to see my client again. I took further instructions. And then when I got back, I could not get in touch with Dr. Ramsey because he was away. I sent him the instructions, and he took a position with it. When he took that position, I then wrote Dr. Ramsey and gave him what advice that I could in relation to the matter. And then he had another telephone conversation with me. And that is what has occurred up to this application.
Yes, but if I may return to the point made by Justice Hayden, surely you have to show some connection between the default of Dr. Ramsey and the verdict. Now, in relation to on the basis of the facts in this case, there wasn't a whole lot of room for maneuver by the accused. And the only one that really appeared to Dr. Ramsey apparently was the failure to, or the absence of the necessary intent, which in the circumstances was not that reasonable. Now there has been raised, of course, another one, and that is diminished responsibility. But as my brother has pointed out, it is not altogether clear how failure to cross-examine the police, or if the police had been cross-examined, how different findings of the facts could have led to a different verdict.
Oh, yeah. Well, I think I answered that question, Your Honor, in two ways. First of all, the question as to the failure to object was certainly drawn to the jury's attention by the judge in his summing up. He said to the jury that the statement had been allowed in without objection of counsel. So, and certainly, Your Honors, in the case of young Sway, I had some difficulty with the name, but it is at tab 9 of volume 1 of your Lordship's bundle. That was a case in which the failure to object to a statement, even though, as I understand it, a voir dire had been held, was held by the court to be sufficient to allow the appeal. And that is at page 118 of the decision, letter B and on. The other case, which I think...
before you go on to the other,
Your Honor.
I'm just looking at the head notes. And it said in that case that the counsel at the trial had, contrary to explicit instructions, failed to put properly to the jury the circumstances in which the statements were made to the police.
Yes.
So there you have a critical, pivotal point. What were the instructions which counsel had? And I think you can't make anything of this case unless you tell us what the instruction, unless Dr. Ramsey tells us what instructions he had.
Or unless, Your Honor, the applicant tells you what those instructions...
No, I'm afraid not.
I'm sorry. The applicant tells you, and you have before you Dr. Ramsey's comment.
Well, we have what the applicant said. Precisely, we don't have what instructions Dr. Ramsey had. And,
my difficulty with that, Your Honor, was that given what I understood to be Dr. Ramsey's first response, I fell into a pickle.
You what, sorry?
I fell into a bit of a pickle, my Lord. In other words, Your Honor, I felt it necessary to say to Dr. Ramsey that he required legal advice.
Yes.
And I just didn't know how I would...
Was it that point he flattened up?
No, when I gave him that warning, the conversation that I then had was different to the conversation I had initially.
Maybe so, but what I'm trying to find out is whether he refused to answer any inquiries that you made of him.
I do not initially, Dr. Ramsey gave me certain instructions which were quite clear. When I put those to Dr. Ramsey, he wrote me back, and the letter that he wrote back did not deal with any of the matters that I had addressed to him in conversation. It did not even condescend on my written notes. It was at that stage that I wrote Dr. Ramsey and said that if you're admitting all of this, you need legal advice. And then he rang me. I would have to say that some of the things that were said to me initially were changed, And secondly, not all of the questions I asked, I understood completely the answer. In other words, Your Honor, I think it's one of the questions I asked was, why did you not obviously cross-examine the police officer? Dr. Ramsey said to me, but I did ask the police officer about the Golden Pussy girl. And I said to him, Dr. Ramsey, it's not there. Oh, he said, or words to that effect. Your Honours, one of the questions that I asked of Dr. Ramsey, before Your Honours, is in fact the respondent's bundle. And in the respondent's bundle there is a letter where the director, the learned director, quite clearly advises the police officers to make available certain information and pre-trial disclosure to Dr. Ramsey. I spoke to the director about this, and he says that his instructions are from the police that that was given to Dr. Ramsey. Dr. Ramsey said to me that he never asked for it, never got it, because it was a waste of time. I have not received any file from Dr. Ramsey. I do not know what that pre-trial disclosure was. If I can just go to that letter quickly, Your Honor. It is in the respondent's bundle.
It was.
Filed on the 27th. The respondent's bundle at tab 2. Oh, sorry. The respondent's authorities bundle.
Oh, sorry.
I'm sorry, Your Honor. I have not seen any of this. I have asked the Crown, and I have asked Dr. Ramsey.
What is it? What is he referring to? Is that? Yeah, no, that's...
Your Lordships, Your Honours will see there that there is advice to the Commissioner in what evidence to be led and what statements are to be made available to Dr. Ramsey. I have made every effort to obtain those statements, and I have not received them. I have made every effort to obtain Dr. Ramsey's file, but it has not been sent to me. I asked for it, thinking that there may have been notes of conversations.
Why would he give you his confidential file? I mean, this is his instructions. I wouldn't give you my instructions.
Well, Your Honor, there are in fact certain things that Dr. Ramsey would be obliged, I think, to give.
Yes, but he would do that in terms of giving evidence or by affidavit or otherwise. But I don't see why he should give you.
What he would be obliged, I think, to give me, Your Honor, is first of all the pre-trial disclosure. That is not his.
I don't see why he should.
But with respect, Your Honor, if I have conduct of a case at the highest level, in circumstances where Dr. Ramsey has no interest in proceeding with it, and he has received pre-trial disclosure in terms of unused material and witness statements, that is material that belongs to his client, not to Dr. Ramsey. And he is obligated to give it to me.
Yes, but Mr. Shepherd, you know, in an effort to shorten the matter, could you focus your attention on how the shortcomings of Dr. Ramsey affected the verdict? What were the issues of fact in this case which the jury decided against the accused, and which but for the alleged negligence of or incompetence of Dr. Ramsey, they might have decided in his favor.
I think it was critical, Your Honor, that the statement being not the accused statement ought to have been put to the police officer.
Well, I mean, why? How did that affect?
Because, Your Honor, what I think, first of all, there was directions on the fact that the statement was allowed in without any form of objection.
So what?
Then there was a clear inference to be drawn that he was, through his counsel, agreeing that he had given that statement.
Well, I don't know.
We had actually signed it in initial bits of it, hadn't we?
Yes, so in other words, until the accused gave evidence, the assumption would have been that he had given voluntarily that written statement.
Yes. Maybe he did.
He then goes on to but maybe he did not, Your Honor.
Yes.
He then goes on to the witness stand and says that it's not his statement.
Yes, but what else of his testimony contradicted his statement?
Well, therein lies another problem, Your Honor. It was none of the details of the statement were not put to the accused. I think we've dealt with that. What was put to the accused is at page, I think it's 126. And you have at line 23, I did not give them a statement, sir.
I know he says that generally, but does he say, and to what extent does he say, if at all, that anything which was in the
Police statement.
police statement was untrue, was specifically untrue, or was
He was led in evidence by his counsel, and his counsel never dealt at all in chief with anything that occurred at the police station.
how are we to know that he had not previously told his counsel that what was in that statement is true?
That surely is something that this court ought to investigate.
But we are not the commission of inquiry. What does he say, for instance, as to why he signed the statement?
His instruction, he just says that he signed it at the time
Why?
because he was in police custody and he just signed it. That's essentially,
You heard the statement read out to it at page 127.
yes, Your Honor.
Yes, sir.
Yes, Your Honor.
But there is a problem, because it may be that he did tell Dr. Ramsey that the statement was correct. Let's take the golden pussy allegation. And so he told counsel it was correct. Then in the witness box he says, no, it's not correct, because he realized the particular problems that we did recognize. I'd like to explain why she was killed rather than left to survive to tell the tale.
And that would,
and that it's possible there may be a statement by someone later saying he did admit he knew her, and therefore he was lying in the witness box, and therefore the statement was correct. And therefore we told Dr. Ramsey that. Dr. Ramsey couldn't have cross-examined on that.
except, Your Honors, that is not what Dr. Ramsey advised me when I first spoke to him. And I thought that would be the simple answer. Given the fact that my instructions from the client were that he never gave Dr. Ramsey those instructions, that he never consulted with Dr. Ramsey, that he never was advised by Dr. Ramsey.
But he said all sorts of things at different times. He told the psychiatrist that he knew the woman. recognized them.
Your Honor,
He denied that.
I think his instructions to me and his evidence on oath are consistent. What is inconsistent is the written statement. That is where the inconsistency arises.
But the written statement is not inconsistent with what he told, well, aspects of it are not inconsistent with what he told the psychiatrist.
I accept that, Your Honor, but at the same time, he has still been consistent since on his examination on oath. What is inconsistent are aspects of the statement.
Yes.
And I have already, I think, said to Your Honors that that was mentioned in the direction. There is one other aspect of this that I think I mentioned before, but I think it is worth just repeating once. Counsel generally in criminal cases is very careful to ensure that what his client says at a later stage has been put to the prosecution witnesses. Simply because it is open to defense counsel to say that if the client says something different on the stand to what has been put to the officers, it is open to prosecution counsel to say that the accused is making it up on the stand. Because if he hadn't, it would have been put to the police officers.
Yes, we are aware of that.
Now we are back, Your Honor, to the addresses.
Let's not go back.
Because if it is that was a line of attack, if it was something that was said, then obviously it would affect the result. In any...
You know, Mr. Shepard, I thought that what was crucial in criminal appeal was what the judge said to the jury, more so than what the counsel may have said.
My lord,
and you know, we keep. I think we're really going round and round a little bit in circles. But I still have not heard you explain what the connection is between whether or not he gave the statement and the verdict of the jury. I mean, assuming he didn't give it, but he heard it, read, and he signed it, and apparently something which was in the statement was not accurate. Something about the girls, the golden girls. So what? How would that have impacted on the verdict of the jury? The only relevance that I can see is that this statement, if it was his, would tend to show that he was very coherent at the time he gave it. So that is something which is perhaps relevant to the issue of intention. But of course, there was a lot of other evidence, some of which has been already referred to this morning, which tends in the same direction.
Your Honor, if I can take you to page 144 of the record, which is at tab 6. That is part of His Lordship, the Learned Trial Judge's summation. You must bear this in mind, line 3. When considering the oral statements allegedly made by the accused in this case, if you accept that those words were spoken, then what do they mean? When considering these those oral statements, you must bear in mind that they were admitted into evidence without objection. As regards the contents of the written statement which is attributed to the accused and which was admitted into evidence without objection, it is for you to say whether you accept that the accused did in fact make the statement and so on. And then, at page 215, line 2, the case for the accused is that he is not guilty of murder, and that he signed the statement, but he never said that he recognized the deceased as one of the Golden Pussy girls from Carrington Village. 215, Your Honor.
215, thank you.
Mr. Foreman, you will recall that Sergeant Greenwich gave evidence in this court. I'm sorry, Your Honor.
215, line 2.
And that it was never put Sergeant Greenwich or Constable Rowe.
What line and what line you say?
Starting at 2, but more particularly from line 6, Your Honor. Mr. Foreman and members, you will recall that Sergeant Greenwich gave evidence in this court, and it was never put to Sergeant Greenwich or Constable Roach that the accused man never said that he recognized the deceased as one of the Golden Boots, so that you do not have the responses to suggestions to those witnesses put in this court.
But what really is the significance, or was the significance of whether he recognized the Golden Girls, or one of them victim as one of the Golden Girls? What is the
I think the significance of that was really that I think the prosecution's case was that having recognized her, he then decided to kill her.
was that?
Having recognized her, he then decided to kill her.
Well, I don't think that was the case. Was that I don't know, but I thought that the case was that he wanted to rob someone to get money, and she happened to be the one who turned up at for him the right place at the right time for her, conversely. But it wasn't as though he was looking for a Golden Girl to kill.
No.
So, I mean, what does it matter?
I think the suggestion was that that when they recognized each other, that became necessary. And I think that was a suggestion which was around. But, Your Honor, more importantly, I think essentially it would have been open to the jury to find that the accused had not told the truth in the stand, or even to his lawyer, in terms of the written statement. And that is the part that I think is of concern. Certainly, it would appear from the full... I'm sorry, Your Honor.
Try to wind up on this point, Mr. Shepard, would you?
Yes, I was saying, Your Honor, that certainly when one looks at the case of Suhan, and finally the Sankar case at tab 10, it is my submission that even that on the fact before Your Lordship, there was an error in relation to the matter that would have affected the result. Certainly the allegation is that the that the accused never had the benefit of advice in relation to his evidence and his choices
What does that mean?
in terms of giving a statement from the dock or going on to the witness stand. And in my submission,
It's the wrong choice.
well, let us put it this way, Your Honor. If it was the intention of the accused to say what he said in evidence in chief, he would have been better off saying it from the dock.
Really? I do say that.
Because it was the cross-examination of the accused in relation to his statement that must have been devastating in my submission.
Why?
Because he was, I think, put in a position where he said he didn't give the statement, and that had never been put in by his counsel, who had presumably conducted the case according to his instructions in allowing the statement in as voluntary. So it was then open to the Crown to suggest.
But that wasn't done. Did he not give evidence to establish the defense that he was totally out of his mind because of the intake of drugs and alcohol?
Yes, Your Honor.
Well, could he have really credibly done that from the top?
It was still to be, firstly, Your Honor, I think it was still to be his choice.
Sorry?
It was to be his choice.
No,
after,
but never mind him. If you were counsel in the matter, do you think that defense could realistically be run without putting him in the box?
I don't think, Your Honor, that it could have been realistically run without the assistance of a psychiatrist. I think it could have been run. I think it could have been run with him in the box and the psychiatrist.
Yeah, but the psychiatrist is another matter. But now we are dealing with your point that we should allow this collaboration and no doubt the appeal because the council let it go into the box.
Well, Your Honor, if I can put it this way, if counsel was aware of the fact prior to putting him in the box, as he should have been, as to what he was going to say, and if counsel was then aware of the fact that he was going to change his mind, assuming that counsel had been instructed in accordance with the way in which he conducted the case, then counsel was placed in a very difficult situation, and that would have triggered the Sankar position.
What?
As it was suggested in the case of Sankar, where counsel is obligated to advise his client in a certain way and withdraw from the case if necessary. If, however, then counsel had a duty not to put him in the box in my submission, in the stand. If, however, counsel was aware that he was going to change his mind prior to going in, was not aware that he was going to change his mind prior to going into the witness stand, then counsel would have put him in the stand, and then he would have given the answers, and then counsel had certain duties which were triggered. But all of that, I think, could have been avoided if there had been a proper consultation between counsel and his client prior to any decision being made as to whether he would go in the box or in the dock.
Yes.
That brings us, Your Honours, to this question of facilities and the right to counsel. Your Honours, I have for the court copies of the Community Legal Services Act, which I think is missing from your Honours bundle. And if I can just make those available. Oh, I'm sorry, Your Honours. We do not. In the amended notice of application, we set out for the court the provisions of Section 20 of the Community Legal Services Act. It's actually it's cap 112A. Murder is a scheduled offense. Your Honours, let me admit at once that there are some difficulties with this argument. Simply put, the cases in Canada, I think, suggest or stand for the proposition that police officers, when they arrest persons for crime, are under a duty to inform those persons not only of their right to counsel, but the capacity or ability to obtain the services of free legal aid at the time and how it is done. That is the case of Bartle and Posniak.
But we are going to rise for 5 minutes.
As you understand.
All right. Yes, Mr. Shepherd, you resume.
Your Honor, I think Your Honor should have before you the Community Legal Services Act, which is Cap 112A. Now, under that Act, murder is a scheduled offence. So once an accused passes the means test, he is entitled as of right to have an attorney of law. The attorney, it is in section 20, where the Act provides that where it occurs to the magistrate or judge that there's a schedule offence, and then there's a requirement for the magistrate to adjourn for financial circumstances. I'm sorry, Your Honor.
But, Mr. Shepherd, we are
I'm sorry,
we
Your
are
Honor.
planning to rise for lunch at 12:30. And we are hoping we'll finish then.
I will, Your Honor. I will.
Thank you.
Section 17 provides
You referred us to section 20.
20 obliges a magistrate
Yes.
to adjourn a matter if
Or judge.
Sorry?
Or judge.
Yes. If a person is charged with a scheduled offence. Section 17 provides that a legal aid certificate may be issued by a magistrate at A, that is when the accused comes before him, except for the fact that it does have a magistrate before whom and at such time he is charged or may appear upon remand, which would appear to me that there is in fact a provision within the Act that allows the issuance of a legal aid certificate prior to remand, except that, Your Honours, I think that the Act is predicated fairly on a charge being proffered. And that is 17, on behalf of a person charged with a scheduled offence. Now, I concede, Your Honours, that there is in Barbados no free legal aid system that provides for the services of an attorney to be given free to persons who are in custody prior to charge, unlike the situations that prevailed in Canada in the Posniak and Bartle cases. However, the Act does provide that you are entitled to counsel at the time once the offence is murder. And although it is a difficult argument, it is my submission that there must be an argument that the police officers at the time are duty-bound to assist the accused, who they are about to charge with murder, at the time when they're interviewing him, and that they should so advise him in the caution. The simple point is, Your Honours, that once a person is going to be charged with murder, any lawyer on the legal aid team is aware of the fact that he will get the certificate at some stage. And the question really is whether in those circumstances the police officers ought at least to have advised the accused at the time that he was entitled to legal aid, that he would be getting one, and that if he wanted to try and get a lawyer on the legal aid system at that time, he could.
But, sorry,
You go ahead.
isn't legal aid premised on lack of financial,
Yes.
financial
Yes, Your Honor.
worth? So that, how does the police officer establish this?
Well, I think, Your Honor, that there would be some indications as to the wealth or otherwise of an accused person, the police officers having taken statements and so on. And I think the police would be aware through police officers that an accused person may fall within that category. And once that is triggered, then I don't see why the police officers cannot, in the caution, say to an accused person, especially who is going to be charged with murder, look, this is a scheduled legal aid offense. You will get a lawyer to act for you. And I'm sure that there are lawyers who will take it up at this stage.
But isn't this a matter for a constitutional motion rather than an appeal from a criminal conviction?
My difficulty with that, Your Honor, is this. I think, first of all, that if there are constitutional points to be taken in any criminal matter, counsel is duty-bound, given what I understand to be the present position, to take those points within the criminal appellate process. Otherwise, you are left with the whole argument on collateral attacks, which was
Section 24 of the Barbados Constitution say that you use the Constitution only as a last resort. You must show that you have exhausted all your other non-constitutional remedies. And I'd have thought that the appeal ground would be one of the first avenues to explore whether, in fact, he was entitled to have this thing read to him.
Otherwise, Your Honor, I think that what is likely to happen is that the whole question of collateral attack may arise simply for this reason. In any constitutional motion filed, it would be a challenge not to the conviction itself, but to the ability of the state to carry out the sentence. And there would be an argument that that is a matter which ought to have been taken within the appellate process, arguably that if the court came to the conclusion that there was such a duty, that the caution itself was inadequate, then there was the whole question of the admissibility of the statement afterwards, which I know also has its own problems. But there is authority.
But you have not made it a ground of appeal that this statement was inadmissible.
I have, my lord, I think in both the first and the amended motion, I have an application. I have stated, I have drawn the court's attention to the question of the Posniak, I don't, yes. Yes, Your Honor.
What exactly are you saying with regard to this? What are you saying the police exactly should have said to the accused?
That murder is an offense which would entitle him out of right to legal representation. And that once that was the case, lawyers would be available at this stage free of charge.
And, is that the law?
Now, Your Honor, I appreciate, I've already pointed out to Your Honor the difficulties in relation to that submission given the provisions of the Community Legal Services Act. But what I am suggesting is that in practice, a lawyer would come out
Really?
in a case of murder.
How could the police advise him that he was entitled to something when he was not entitled to it?
Well, the police would be advising him that he was entitled to be legally represented by a lawyer at his trial. That is something that even the Community Legal Services Act provides to the magistrate to inform the accused. That is the advice that the police would give.
Represented my lawyer at his trial.
But that is not information that he may have known at the time of his arrest.
How would that affect anything?
Because
he knew it at the time of his arrest or not, provided that he knew it before he went to trial.
Because
what difference does it make?
Because it's in
practical terms, Mr. Shepherd.
No, I understand what your Honor's problem is, and I have already said that it is a difficult argument. But I am saying that if I am told that I am entitled to a lawyer for my trial, and I know that I'm entitled to a lawyer for legal aid, the first thought that comes into my mind is, why can't I get him now? I don't get him at my trial, I get him prior.
You get the legal aid lawyer first, or what happens if the legal aid lawyer is in the wings and he comes in?
Yeah.
And
even though then we have problems with
how
that.
does he get the instructions? I mean, the legal aid lawyer.
What normally, the legal aid lawyer can be triggered in a number of ways in practice.
But that's not how, I mean, normally, doesn't it come from the legal aid authority that tells the lawyer, look, this is the case we would like to do?
Yes, but it doesn't always have. For instance, in this case, Dr. Ramsey went to the accused the following day.
This is not a legal aid case.
Yes, it was, my lord.
Oh, I see.
It was.
Sorry, Dr. Ramsey was actually...
on legal aid.
I see.
Well, given the time constraints, you might move to a less difficult argument.
My lord, as a corollary to that, before I move on to diminished responsibility, which I'm going to ask the lordships to hear Mr. Khan on, I will say this. The legal aid provides for a stated amount for a lawyer. I think it's something like $5,000. It does not provide for any other assistance to the accused. There is in my submission an argument that the Legal Aid Act, the Community Legal Services Act, does not go far enough to provide for a fair trial of accused persons where those accused persons face charges of murder. In this particular case, assuming that the evidence, that the instructions were that the statement had in fact been given, this appellant, or this applicant, had in my submission, your Honours may disagree, one possible defense, and that required, in my submission, the assistance of a psychiatrist. That is not afforded. Now, that perhaps is slightly unfair to say that it's not afforded. I ought to say two things. First of all, in the case of Aiken, Oklahoma, which is before your lordships, there appears to be a threshold test that lawyers must satisfy the court in order to obtain funding for psychiatrists in murder trials. We have no such motions procedure, firstly. And secondly, the position of the Crown in this regard is well known, and it is this, as I understand it. The director will correct me if I'm wrong. But when a person is charged with murder, they are brought before a psychiatrist at the mental hospital for the purpose of the psychiatrist deciding whether or not the person can plead. It is a relatively quick investigation. The Crown argue consistently that if defense counsel wish their clients to be interviewed by any psychiatrist, a relatively simple procedure is adopted, and that is that you make an application to the superintendent, and the superintendent makes your client available to somebody at the psychiatric hospital. Defense have consistently argued that that is unsatisfactory, as the psychiatrist at the psychiatric hospital is a government employee and is not to be equated with somebody who provides medical services on the National Health Service, say in Britain. And that what defense require is in fact access to independent psychiatrists who can in fact interview and give the defense some idea. Now I have to say, my lords, that in this case nothing was done about that. No attempt was made to have the accused interviewed by a psychiatrist, even at the mental hospital. That was not done. It appears to us, or at least it is our submission, that that was an error that may have affected the result and robbed the accused of one essential, we submit, limb of defense, namely diminished responsibility. And that takes me back, Your Honor, to the question that you asked me about the question as to whether or not he could have even gotten as far as he did if he had given evidence from the doc. I think that with some form of medical psychiatric evidence as to his state of mind and the sort of evidence that we have endeavored to put before the court in the limited time that we had and the limited facilities that we had, that the appellant or the applicant ought to be given the opportunity to pursue that line of defense. There remains simply, Your Honor, unless there's anything I can... Oh, sorry, Your Honor, there is one other point. I spoke to the learned director in the, very briefly in the break. I think it's fair to say this. In cases where counsel is challenging the fact that his client made the statement which he admittedly signed, what normally happens is that when the statement is proffered, counsel would say, I am objecting to this statement on the grounds that it was not made by my client. There would then normally be some inquiry between bench and bar as to what that exactly meant, whether it was beat or whatever. And that having been clarified, I now understand that no voir dire is heard. But I do remember, and it is some time ago when I was at the criminal bar, there seemed to be a general leaning of the trial judge, even in circumstances where the statement was being challenged only on the basis that it hadn't been made, to err on the side of caution and exercise the discretion to hold a voir dire. But it is not necessary. What would then happen is the statement would go in, and then obviously there would be cross-examination from defense counsel on the circumstances of the giving of the statement. But in these circumstances, the clear inference to be drawn would have been that they were consenting, as it were, and that there was no challenge whatsoever to the statement and the fact that it was made.
Mr. Shepherd, I can well understand your point that if the accused denies making the statement, and at the point when it is tendered in evidence, that this should be made communicated to the judge and the jury. But I do not agree that it should be in the form of an objection, because that there is no basis for objecting to the admissibility of such a statement. And I certainly do not agree that the judge has the latitude to conduct a voir dire, although none is necessary. No voir dire should be conducted. Full stop.
Yes, Your Honor, while I accept that, I can only say that certainly I am aware of the fact that in practice, maybe not now, but I'm going back to the 70s and the early 80s, there was a lot of discussion about what would trigger a voir dire. And the general feeling at the bar at that time was that you are on the side of caution. I can only say, you're holding.
They have been, before the matter was put beyond doubt, my privy counsel in Ajoda.
But I am aware of one incident, Your Honor, in relation to the Ajoda where I actually objected to a statement going in. It was on the grounds that it had not been voluntarily given, but I said that the jury were not to be removed and the voir dire or the case was to continue in the presence of the jury on the authority of Ajoda and some other cases. The trial judge disagreed with me and sent them out.
Yes.
And I successfully argued in the Court of Appeal that it was not necessary. I only bring that incident to Your Honor's attention in that while the cases may appear to Your Honors as being very clear, they are not always so clear in the light of what counsel says or what happens during the course of the trial.
Well, and I think counsel should be allowed to confuse the situation.
Oh, I could not agree with you. Certainly I say this, that I think at one stage there was certainly an attempt to try and word one's objection in such a way so as to trigger some discretion in the trial judge, even though you knew that the basic objection was, look, it wasn't my client's statement. My Lords, I ought to just draw also to Your Lordship's attention that Your Honour's attention in the decision of the Court of Appeal in this matter, it appears to me, for what it is worth, that the court did pay some attention to the fact that the statements had been admitted without any objection, and that is at page 2, paragraph 2 of the Court of Appeal decision.
But I don't know what the Court of Appeal or the trial judge had in mind when they drew attention to the absence of an objection. To the extent that they were referring to the absence of any allegation that the statement was not voluntary, I can find no fault with it.
Except, Your Honor, that I think that the court was, within the context of Barbados, surprised that no objection was being taken, as it would have been interpreted as an admission that it was his statement and that it had been given voluntarily. And that would have been, I think, confirmed by the lack of any examination of the officers on that basis. And that is why I think...
Again, assuming that they intended to refer, which may well be more likely, to the absence of any suggestion that the statement was not given, then there is nothing wrong or improper with that drawing attention to that.
Oh no,
although you are asking us to treat it as something which unfairly prejudice the accused, because his counsel failed to point out that his client's instructions to him were that he didn't give the statement. But your complaint is premised on the acceptance of the instructions which you have now received.
Yes, yes, Your
Honor. There is, you have a hurdle to overcome in persuading us to act on that premise.
Your Honor,
let me say this, that we cannot shut our eyes to the evidence you have provided of what he said to his psychiatrist. And it would really be taking a very thinking view of the matter to find that the counsel had acted without instructions, or had not taken instructions, or had not acted on them on the basis of a alleged discrepancy, which you say was the result of a fabrication by the police, when in fact the version given by the police on your account in the statement tallies with something which your client gave to the psychiatrist.
Your Honor, first of all, I think that it's not only the lack of objection, but it also is the failure to cross. And there has always been, to my mind, one great mystery in the case, and that is, why is it that the accused gave the evidence that he gave on the witness stand in light of the manner in which the case was conducted? That I cannot understand. Now, I think that if one accepts, if one looks at that in broad daylight, the outcome was assured. I don't think there's any doubt about that. Simply because, for the reasons that I've already explained, and I won't go back on them. But my point is this, Your Honor. Having come into the matter at this stage, I've taken Your Honors through what I have done in terms of taking my instructions, going to Dr. Ramsey, coming back, going back, and all the rest of it. And I have, in fact, had some difficulty in dealing with those issues simply because of some of the responses I received from Dr. Ramsey in terms of the use of the word tutor that I think I mentioned.
You're going over old ground now.
I'm sorry,
You're going over old ground.
I am. And,
but I thought, are you going to address anything further on the reference to the psychiatrist report?
Well, I think my learned friend, Mr. Khan will. My Lord, the reason why I was going, Your Honour, the reason why I was going through that old ground is because I have to be careful to ensure that if Your Honours reject the application, it is not through any lack of forensic skills on my part, or alternatively, Your Honours, something that I ought to have done in terms of those instructions that I did not do.
Yes, I understand.
Unless there is anything further I can assist Your Honours with, I would ask Your Honours just to hear Mr. Khan on the diminished responsibility point.
You're going to ask?
Mr. Khan, Your Honours to hear Mr. Khan on the diminished responsibility point.
Yes, I see, yes. Well, thank you.
Thank you, Your Honours.
Thank you, Your Honours. I propose not to spend too long on this, as I'm aware that the constraints of time have their effects. In terms of the very brief submission I intend to make regarding diminished responsibility, can I take their honours, first of all, to the case of R. Deichmann, which is at tab 31 of volume 2 of the bundle. Specifically, Your Honours, can I just direct your attention, first of all, to page 1209. Your Honours, if I may just say that in terms of guidance, the House of Lords specifically approved R. and Gittins, a case from 1984, Queen's Bench Division 698. And if I can take your Lordships to 1222, the 4 principles that were derived from Gittins are restated in R. and Deichmann, and the responsibility of the judge's directions regarding diminished responsibility. Now, I think that these are very important on behalf of the applicant, because had the defense been raised, these would have been the specific directions the judge would have had to have given, and that's obviously within the notice of application and the amended notice of application. We have provided a very preliminary report from Dr. Mehi, and we understand that it is very, very limited, given that he was only able to meet the applicant on one occasion in very difficult circumstances. My Lords have that available to them in the original notice of application, which is dated...
But it says then, that is the time of that interview, the doctor has not had the opportunity of interviewing it further.
The problem has been that we paid for the doctor to undertake that initial examination, Your Honour. We funded the doctor to take that initial examination. We have tried to secure further funding through the application for legal aid and legal certificates, and we have hit a wall on that issue, Your Honours. And I think that I don't wish to rehearse too much of what my learned senior has said on this point, but there are difficulties in terms of securing additional psychiatric assistance. And we are endeavouring to ask and seek his further assistance should the application for leave be granted, Your Honours. So that's why we are left at this point in time with a preliminary report.
I can understand that, but it's rather late in the day, isn't it, to come up with this diminished responsibility point. Obviously, it should have been brought out at the trial itself. Clearly, Dr. Ramsey himself didn't think there was anything in it, or he would have raised it. And nothing comes out of the evidence. It just seems to be an example, one might say, of a member of the underclass lying, drinking, smoking for a considerable period of time, then deciding to rob someone, and then someone gets killed. What special and out of the ordinary is there to suggest diminished responsibility?
Your Honours, I can take you through the trial record, which I intend to do very briefly. However, there are particular circumstances regarding Mr. Cadogan's developments, his childhood development, which Dr. Mehi alludes to in this report. The fact that there is an abnormality which falls within the Deichmann and the limbs of diminished responsibility. And further, despite the fact that this wasn't canvassed by his original trial counsel and at appeal, there is an inherent responsibility on the judge at the High Court trial to have brought this at the very least to the attention of counsel. Sorry.
Cutting the chase. What concerns me about the diagnosis, the preliminary diagnosis of the doctor, is that it seems to me that it could fit a whole a substantial part of a whole generation. You know, of defiant behavior in puberty and aggressiveness, threatening kill a teacher or something of that sort. That regrettably is behavior which is no longer abnormal.
Your Honor,
I don't know if putting a tag to it, personality disorder, if that is really distinguishes it from the sort of malaise that produces so much in the way of crime among young people.
Your Honor, I take the points. However, Your Honor, the jury didn't have the benefits of giving or looking at the probity of such an argument or the probative value of such an argument. They weren't provided with the benefits of making that determination themselves. I don't hold myself, nor does my senior hold himself out to be any psychiatric expert. However, we would seek the application for leave would hopefully be granted, and we would then have the opportunity to provide further information regarding both the psychopathic and the abnormalities within Mr. Cadogan's behavior.
Mr. Kant, one of the things that concerns me considerably is that here we have a trial, we've gone through a trial where the defense has basically put the prosecution to proof and has relied on the fact that the prosecution may not be able to establish intent. You've gone through that trial and you've lost. And then now you want to have a retrial on the basis of another defense, diminished responsibility.
Right. Our client's instructions are very specific regarding the incident on the 8th of December. He stated in his affidavit, he stated to us repeatedly that although he recalls the first stab, he doesn't recall anything after that at all. Now, it's our contention and it's a submission that there are issues which would have rendered that the jury had diminished responsibility put to them, whether it was by defense counsel or by the judge, is a question that needs to be determined as part of the application.
Mr. Khan, isn't it normal that you have some kind of medical or psychiatric evidence in order to ground the defense of diminished responsibility? In fact, it's been so held, hasn't it?
Right. My learned senior talked to the role of the psychiatrist in terms of the state psychiatrist rendering some sort of psychiatric assistance. My understanding is that the hospital psychiatrist now be corrected is there simply to determine fitness to plead and does not provide.
I'm simply on the question of what medical evidence would have grounded this defense of diminished responsibility and have caused the judge to put that to the jury.
Can I take your honor to the trial record?
Yes, I'm asking for the medical evidence.
The medical
evidence that would have alerted the judge that that was a possible defense.
The medical evidence that we have is the exhibit which is attached to the original notice of application, which is entitled Exhibit 1 by Dr. George Mayhew.
Was that at the time of the trial?
At the time of the trial. None was provided at the time of the trial.
At what? Sorry?
None was provided at the time of the trial.
Yes.
And that is the difficulty.
Are you really pursuing the ground that the judge ought to have raised diminished responsibility at the trial?
Yes, Your Honor. We are, because we could, in terms of authority for that ground, I would wish to cite you R. and Campbell, which is...
How could you raise it? What he advised it, the defense to do so, or what?
R. and Campbell speaks to the responsibility of the trial judge where he detects or notes that there may be other grounds, such as diminished responsibility, and brings back to the attention of defense counsel. Now, it's an authority the judge has, and R. and Campbell speaks to the judge asking the jury to leave and to bring it to the attention of defense counsel. If I can take your honor to that, I would think that would be a...
Well, I don't know. It's good. I thought, but you have authority for the proposition that if defense does not raise diminished responsibility, that there is an obligation on the judge to raise it. And if he doesn't, then the conviction may be quashed. You have authority for that proposition.
Your Honor, there are other cases which I could direct your honors to, which have not been submitted as part of today's bundle, which have not been submitted as part of today's bundle, but they provide clear authority that the judge has a duty to raise defences to the jury.
Judges
has a clear duty to raise defences to the jury, which may not have been raised.
I'm not on defense. I'm on diminished responsibilities specifically.
Diminished responsibility would fall within one of those categories of defense.
Oh, well, you're not answering me, you see. I'm asking if I have any case that deals specifically with the duty of a judge to raise diminished responsibility as a defense. You see, Mr. Khan, we all appreciate that if the evidence discloses a possible defense of provocation or self-defense, and whether the defense raises it or not, the judge must bring this to the attention, and he must raise it. That is on the basis of the evidence which has been led. But in a case like ours, where there has been absolutely no evidence whatever led of diminished responsibility, to suggest that the judge must intervene and call for evidence, presumably of it. I find that is going a lot further than I am aware that the law has ever gone.
What's more is that the trial judge, clearly adverted to the fact that the defense were not seeking to rely on diminished responsibility. The judge was aware of diminished responsibility as a defense to a crime of murder, but the judge adverted to the fact that the defense were not relying on that, as the defense were not relying on provocation or self-defense. It's at page 206 of the summing up.
Mm-hmm. Yes, my lord. My lord, I have that in front of, Your Honor, I have that in front of you, which is at page 206. Can I also direct your Honor's attention to page 156 of the trial record.
152.
152. At line 17 downwards. Mr. Foreman and members, if because of the accused's consumption of alcohol and or use of drugs, in this case of marijuana, you will believe that the accused's state of mind was such that at the time of the stabbing, his ability to exercise voluntary control over his acts was totally destroyed. Now, I would contend, Your Honor, that that certainly speaks to diminished responsibility in broad terms.
Diminished responsibility must arise from certain specific sources, which are enumerated in the provision. And drugs and alcohol are simply not among them.
Your Honor, I directed Your Honor's attention to our indictment, which looks at both the role of drinks and drugs and diminished responsibility, and how that needed to be directed to a jury.
That's where there's something else on top of the drugs or the drinking. There's nothing else here, is there?
That's correct, Your Honor. However, had the judge brought that defense to the jury's attention, then that would have been a specific, or to counsel's attention, that would have been a specific defense that should have been raised.
You see, if the judge, on his own initiative, introduces diminished responsibility, and the jury bring in a verdict of guilty or manslaughter on that basis, you may well have an appeal in which the defense complains that the judge ought not raised it, and if he hadn't, it was an acquittal.
Not in this case, Your Honor.
You were quite right.
Your Honor, there is, of course, the alternative, which, again, I can cite to you because it has not been provided as part of any bundle. And that is the case of Ramdeen and the State, where fresh evidence was adduced on a second petition for leave to the Privy Council at the time regarding the defense of diminished responsibility. Now, I recognize that it's tardy of me to do so. However, I think that given the mandatory death sentence is hanging over this individual's head, it should form part of the contemplation when delivering.
I have a problem with that submission, precisely how it is made, because it seems to me that these kinds of arguments are really to be deployed before the Barbados Privy Council. Anyhow, let's see the case.
I have the case available for you in the buff folders.
But in Ramdeen, from early on, the defense of diminished responsibility was raised, wasn't it? I mean, as far as I remember.
No. Your Honours, I think there's a difficulty here. I'd asked for it to be copied. I am probably at fault here, and I think I should make this available to you at a later date. However, if Your Honour...
What is the principle that the case...
The principle here is that, if I can just read the holding. A petitioner had been convicted of 2 murders and sentenced to death. Her appeal to the Court of Appeal was dismissed, and her appeal by special leave to the Privy Council was also dismissed. At a later date, new evidence became available suggesting that the petitioner had been suffering from such abnormality of mind at the time of the killings that, had the evidence been available at her trial, a defense of diminished responsibility might have been established, and a verdict of manslaughter might have been brought in against her rather than the verdict of murder. And it was held that because of the importance of the issue which emerged from the petition would be adjourned for hearing by a 5-member board, and the hearing of the appeals would follow if leave were granted.
In that case, the prosecution had given evidence to a psychiatrist, Dr. Hutchinson, and he said that the petitioner was not suffering from any disease of mind, and that she may have suffered from mild depression at the time of the killing. That's very early on. Trial. This wasn't so. This is the prosecution were trying to sort of negative any defense, any potential defense of diminished responsibility, and that went through. There was no contest to that evidence. But later on, after they lost, they got psychiatrist, an English psychiatrist, a distinguished English psychiatrist, examined the appellate. And that is what put into question what the original evidence was about diminished responsibility.
Your Honour, again, without rehearsing my learned senior's arguments or his contentions, we asked for disclosure of all unused evidence throughout this process. In fact, my learned senior has provided a letter, which I believe is in the buff folder, which asked the DPP to give us unused evidence, and that included the evidence of Dr. Bell, who is used by the state to determine the psychiatric condition of people who've been charged with murder. And to date, we haven't received that.
You've not seen that evidence?
We haven't seen the evidence. We've asked for it.
I'm not hearing it.
Evidence of a Dr. Bell, who had examined the applicant.
This case,
Yes.
with this applicant,
Your Honour, we initially sought all pre-trial disclosure from Dr. Ramsey, and as my learned senior explained to you, we had difficulty in obtaining that. We then wrote to the DPP and were told, to the learned director, that all the evidence that was available was in the transcript. However, we became aware of a letter which is part of the case authorities, I believe it's tab 2, which refers to unused evidence, which included the statement of Dr. Ermine Bell. And we've asked for that. We haven't received that.
Was he the government psychiatrist to have such little in him?
Yes, yes, Your Honour.
Yes. If your affairs are well funded, then his report is not right to assist. But you know, if I return to the point I was on earlier, you know, in the cases I've seen in which either has been remitted or the appeal has been found on the basis of psychiatrists' report that was in after the conviction, that report has contained something of real substance, you know, that maybe possibility of brain damage consistent with the history of a blow to the head or other symptoms of epilepsy, or you have a depressive major depression, and we were all led from these psychiatric reports and evidence that depression is can be a very serious condition. But what we have here, I don't want to be impolite to the doctor, and maybe due to my ignorance of matters psychiatric, but it's a little very, personality and disorder. I mean, most of us have some personality disorders.
I would not comment on that, Your Honour. Thank you, Your Honour. Your Honour, I gave a precautionary statement at the beginning that this was entirely a preliminary examination, and the cost was borne by our chambers without any assistance. That is not to seek the sympathy of Your Honours at all. It's just to illustrate the stark reality.
You mean it might explain the quality of the report, or?
No, just the preliminary nature, Your Honour, not the quality of the report, because again, I wouldn't speak to that as I'm not the expert to determine his.
So much of this report confirms duality in other respects. There is so much of the report which says that there's another ground with him. But, he is and it's an analyst, a young analyst. Yes, okay. But, as I said, that's hardly me.
I'm just going through the report now, Your Honour, and it talks, again, I would suggest to Your Honours that this, given the preliminary nature and the amount of time spent with the individual, it does, however, provide an illustration of the type of individual Mr. Cadogan is deemed to be by the psychiatrist. For example, at paragraph 5, which is the second page of exhibit number 1, it talks to, from the account he gives of his lifestyle, he has a major personality disorder with a strong psychopathic element. Now, I would suggest that that doesn't apply as a norm to the general population. I would hope it doesn't apply as a norm to the general population.
Well, but I agree, some of the songs are very impressive, but on what basis is that the idea of a psychosis or a psychotic on the basis of what is must be on the basis of what is said out in the report. And perhaps you might like to examine that. But I think one does seem to be the rather heavy burden to put on a rather light foundation.
It's a foundation, nevertheless, Your Honour, to which there are reasons in that there was limited exposure of Mr. Cadogan to the psychiatrist's evaluation.
But what would...
From the evaluation in lifestyle, he has a picture which has to be with a strong
Psychopathic elements.
Lifestyle, what was his lifestyle? Johnny or the important discipline, they get the clothes and sometimes we want to staff who get threatened to give us a yeah, I suppose. He was a pretty aggressive fellow.
What is the psychosis that we're dealing with here? Is it a psychopathic...
Yeah, that was at line number point number 5 from the account he gives of the...
Yeah, but what when he refers to this psychopathic element, is there anything here that tells us what the psychosis might be?
I believe, but again, this is asking me to speculate on the expert's behalf. However, I believe he's founded his psychopathic element directly upon the personality disorder.
Well, you know, he says in the introduction of the report that the subject denied ever having any features of a psychotic illness, like hallucinations, delusional systems, or gross thought disorder. So, you know, if you say he has a strong psychopathic element, well, I don't know. Does it say anywhere what's the nature of that?
What he says here, he says he was well-oriented and denied ever having any features of a psychotic illness like hallucinations, delusional systems, or gross thought disorder. He gave a history of someone who was very defiant in his childhood. In his adolescent period, and a lifestyle of using alcohol and marijuana in late adolescence and adulthood. He reported that he was expelled from secondary school, was threatening to each other and using the word kill against art. His alcohol and marijuana use. That his little friend was an active participant. I asked him directly how the relationship and he did, and they had frequent sometimes trouble fights. And he showed me a scar, which he gave that I was particular to that move from his girlfriend. I wonder whether she had the same disorder. I questioned him. He said that he needed money to go on that is the basis of his diagnosis.
Your Honours, again, to underline, Dr. Mayhew is quite clear at the beginning. Because of time constraints, I was only able to see him, or was able to see him only once. So I cannot give a definitive opinion at this time. However, what he has given is a straightforward account of his meeting with Mr. Cadogan and his assessments at that meeting. On this point, I would submit to you on behalf of the applicants that there is considerable ground here that a defence of diminished responsibility should have been put to the jury. And had the facilities been... should have been run. I apologize. And had the facilities been made available, there certainly would have been something within the ambit of the jury to regard.
But in the light of this report, what are you asking this court to do?
We are asked...
Putting know that in the first instance you're asking for special leave to appeal, but assuming that leave were granted, what would you be asking us to do on the basis of this report?
I would ask the court to agree for funding for a psychiatrist and lawyers.
What?
Funding for a psychiatrist and lawyers to pursue the appeal.
Funding for
Funding.
psychiatrists and for lawyers.
Psychiatrist.
Dietrich. R. Dietrich is a proposition for that.
Why do you have to also little
I'm sorry, Your Honor. R. Dietrich is a proposition for that particular submission.
You have a...
I can refer you to that, which is...
But I'm afraid,
Are you saying the court can order someone to provide funds? And who would that person be?
No. What we submit, Your Honor, is that they can give leave and stay the appeal until that funding has become available in order to conduct the psychiatric assessments.
You have to raise your voice.
Right, sorry. I apologize, Your Honor. R. Dietrich, which is at tab 21, volume 1 of the cases, speaks to the proposition that the court can stay the proceedings until psychiatric assessment has been carried out.
how... That was a decision of what court?
The High Court of Australia.
Yes. That was, I see, our view to them.
That's correct.
So that is what you were asking us for. No, there was no indication of this in the application as filed or as amended.
You're correct, Your Honor, and we reserve the right, Your Honor, that we would add further submissions.
Yes, I know, but you got, you know, this keep on, like, just adding something to go along. In fact, there is something I would like to say, and it is this. I mean, it become, it has some kind of, in a feature of appeals to the Judicial Committee on the Living Up from the Caribbean. That matters were raised for the first time before the Judicial Committee. And in fact, sometimes they were not even raised on the first visit to the Judicial Committee, and only on the second application. And I am disturbed if this case is any crime. I would like to tell that pattern they become repeated in appeals to this court. And I certainly would not want that to happen. I'm not sure what the answer is. I'm not big, but I want to make that clear. And I certainly would like, would hope that some be found to ensure that all points were in the matter taken reference at the trial, but it's not there. He's before you.
Your Honour, unless I can be of further assistance regarding the issue of diminished responsibility, my learned senior would wish to take that point directly. Would wish to deal with the point, answer the point you've made.
Very well, thank you.
Your Honour, I think the real problem comes first of all in relation to the profession, and we've had this conversation before. The point is that the prison is hot and the fees are low, and therefore you will get complaints from persons accused that they're not seeing their counsel enough, that enough consultation is not going on. You're also going to get complaints about the representation. Now, that is going to continue in relation to High Court and Court of Appeal. When you come to the Cadogan Court of Justice, Dr. Ramsey wouldn't take it on. We had some difficulty in relation to the funding for this application itself. We asked for fees, or we asked for airfares. We were denied airfares. We were told to deal with the Director of Public Prosecutions or to deal with Community Legal Services. Similarly, in relation to appeals to the Privy Council and substantive appeals. So what is going to happen is that you're going to get different counsel at this level to what you are getting in the High Court and in the Court of Appeal. And once you have different counsel, the likelihood is of these things continuing to happen. And they will, I think, continue to happen. I mean, Your Honours have I know, given me a fair hearing in relation to the instructions and so on. But the point is that I think at this stage, what is the court doing? The court is deciding whether, I think, to shut the door on this applicant. And in my submission, the door should not be shut on this applicant. On this applicant should not be, and this applicant should be allowed to ventilate these matters, and perhaps out of that, some form of system can be put in place. The state has chosen to retain the death penalty, and it has been my contention from the beginning that if you choose to retain that death penalty, then it's incumbent upon you to build within your system some safeguards in terms of your representation and your facilities and so on. And that is not there.
I don't pretend to know what the solution is or what is reasonable an idea of resolving the problem. I'm sure that the efforts of our council to give their services pro bono in matters like this are to be praised for it, commended. But I don't know if it's narrow interest in a sense. Some arrangement could not be made, however important, where they might operate as consultants at the level of the High Court and Court of Appeal. If the case that they are going to come into the case when it reaches us, I think that their job at ours would be made a lot easier if there could be some such arrangement where their input could be received from the early stages.
I accept that, Your Honor. I do accept that, and I think that may be the answer to the workings of legal aid.
I am very strongly that we cannot and should not allow this wasteful pattern of litigating to be perpetuated.
There is
Wasteful, obviously, because it may have from time to time involve in rehearing of appeals.
There is,
and even involving a rehearing or hearing of fresh
evidence.
There are decisions made which are not always easy as to whether there is justification for extending the process.
But, Your Honor, there was an argument that was raised in the petition, and that is that in cases of murder there should be at least two counsel. I mean, there is, even though the Crown may argue differently, there is no tradition in Barbados of saying that silk has to lead, or that there should be two counsel in relation to murder trials. And it is difficult to conduct a case in relation to a murder case if you are doing it on your own, if you are forced to do other things such as go to a psychiatrist and so on, where your fees are X and you have your practice to run. And certainly we put it in the petition, and I didn't open on it, but the point is that I think that there is a constitutional argument that there is an entitlement to more than just one counsel for a murder case. And, Your Honor, if I can make this one final point about pro bono. I think it is fair to say, and perhaps this is my own assessment of it, is that counsel who have normally given pro bono services, say in the United Kingdom, are counsel of very high repute, are usually counsel that have access to other briefs. So it is always in my contention that the acceptance of the pro bono brief may not have the impact in terms of what it would have to somebody who is in practice within the Caribbean, who usually is not in a chamber system and who has to find money each month in terms of staff and rent and so on. And it is that kind of pressure that shows itself in relation to the representation of some people.
Well, of course, there are other possible solutions which are involve the raising of standards among the bar generally, and also has to do with the allocation of legal aid work. With regard, although we are closer to Barbados than the council was, I think that it would be more appropriate for any specific recommendations that might be made for the improvement of the legal aid system come from the Barbados. So that I think for the moment I would say no more.
Except, Your Honor, that they have declined in the Licorice and Nelson case to hold that a murder accused who got leave to appeal to the Judicial Committee of the Privy Council was entitled as of right to funded counsel. And I can make that decision available for Your Honours, because that was argued it was argued given the constitutional right to a fair trial, once that the accused was entitled to a funded attorney at law at the level of the Judicial Committee of the Privy Council. And there's a decision of the Barbados Court of Appeal which says virtually it's a good thing, it's not a constitutional right, and we really think the Crown should do something about it.
That's all right. Thank you.
Oh, my lord, I will give to your clerk or to the registrar the Ram Martindani decision, which I now have, in which your lordships address the question of leave.
Yeah.
As your honor, please. I know.
Well, we can rise now, and we will come back at 2:15.
As your honor.
Thank you. All right. Mr. Leacock, I think it's your turn.
May it please your honors. If I may respond seriatim in terms of my learned friend, the points he has raised. Indeed, he started with the issue of intent, council error, facilities, and diminished responsibility. My learned friend's first contention, if I understand him correctly, is that the gravamen of his submission on the issue of intent is that the direction on foresight of consequences should have been left to the jury. His submission is predicated on the case of Woolen, in which he submits, in his view, that foresight of consequence was an appropriate direction to leave on the facts of this case. My lord, it is my, your honors, you will pardon me, being accustomed to that language. But your honors, it is my submission that each direction must be custom made to reflect the factual situation in which it arises. And on this, and in the instant case, there is absolutely no need nor no basis for a direction on foresight of consequences based on the Woolen test should have been given. The basic reality is that Woolen is a case in which an adult had dropped a child in circumstances where the father had loved the child, was a caring father, and in those circumstances the whole question of foresight of consequences could have arisen. And also the case of Maloney, where both the father, the stepfather, and the son, who was a soldier in Belize and had returned and they were having a family party, and it was in that context in which he was shocked, in circumstances in which they were really discussing who could outdraw the other. Those are cases in which absolutely no harm nor intention was ever intended, but the parties had known each other, there was no animus, there was no malice, and there was no intention to hurt. Those cases are in contradistinction in which foresight of consequences was left. Those cases are in contradistinction to the realities we have before us today. We have a case where there was a deliberate intention by Mr. Cadogan and another to rob in order to get money. Mr. Cadogan had armed himself with a lethal, or rather a murderous weapon, a 22 centimeter knife, butcher's knife that he had found and was in his possession. He had furtively hid himself and in fact concealed himself from the police who was passing, even a relative of his who was a police officer who had also passed that night, and had also waited to allow two other ladies to pass because their passage, thankfully, was much too close to the passage of the police officers. He then launched a direct attack on the deceased and the night in question, and in those circumstances, this is not an appropriate factual situation for any direction on foresight of consequences. This matter was clearly cogitated upon by the Court of Appeal in Barbados, and they've given a rather reasoned judgment, which I'm sure your lordships have read. I will not really bother to trouble you much with it unless you wish me to, but suffice it merely to say that page 41 of the judgment at tab 5, the decision of the Court of Appeal, page 41, or is it paragraph 41? Yes. At paragraph 41, page 32, Your Honours. The Court of Appeal had this to say through Simmons, Chief Justice. It seems that directions will vary as to whether the case is one of direct attack or not. So Leoc says that this appeal concerns a direct attack. We agree. Notwithstanding the appellant's evidence that he intended only to rob the deceased, it was for the jury to decide whether he intended to kill her or to cause her serious bodily harm by paying regard to all the relevant circumstances, including what the appellant himself said and did. I haven't been able to show it because it's much easier for me to read from a pair. But I haven't lost you, my lords. Yes, we have done. So, my lords, your honours, it is my submission that this was a custom-made direction predicated on the facts before the relevant court. The factual situation on each case would vary, and therefore the directions would have to vary to reflect the nature of the evidence. The nature of this evidence did not reveal any need for a direction on foresight of consequence. And to seek to stretch that definition, to seek to stretch foresight of consequence direction, as is applicable in the Woolen and Maloney case, to fit the facts of this case, is wholly misconceived. This is not a case for which that is merited, and the Court of Appeal in Barbados reviewed this matter, the entire history of the cases, as was brought to their attention, tracing the history of the law from Smith right through to Woolen. And in my respectful submission, they gave the most reasoned and correct decision on the matter, and they quite correctly characterize it as a case in which such directions should not apply. Being a direct attack, it was essentially a matter for the jury to decide what the accused would have intended in light of what he did. And in assessing the accuser's intention, Your Honours, the jury were entitled and were indeed obliged to look at all of the evidence. What he did, the manner in which the attack started, it was a deliberate plan to rob. It was a plan by himself and another. It was a plan in which he waylaid the deceased, whereby he waited for the coast to clear, he avoided the police's presence, he hid behind a hut, and then when the police actually came, if he was so frozen or so incapable of thought, what did he do in the circumstances? He actually ran away. He hid himself and he escaped the scene from the police on the night in question. This is clearly the actions of a man who's quite coherent, who's quite logical in his thought process, and who clearly appreciated and knew what he was doing. And more to the point, if I may address this issue of intent on another matter, it was an issue during his cross-examination when he was on the stand as to whether he'd actually recognized the deceased. And that was an issue, as the record would show. He denied in cross-examination that he had recognized her. In fact, his written statement, which is at page 109 or thereabouts, clearly said that he knew her as one of the Golden Girls. But he denied this in cross-examination. Yet we have as recently as this year, in June of this year, when he was being examined by the psychiatrist, we have him saying quite clearly, which the learned president read, and I'm not going to read it again, but the very last two sentences he said, when he said that she turned around, and when about the penultimate line there, she said when they turned around, when their eyes met. He said that she turned around, and when their eyes met, they both realized that they had known each other. He stated that he cannot recall any further contact with the woman he attacked, but he recognized her as Paulette Brathwaite, somebody obviously whom he had known. So that, Your Honors, is what he actually says to his psychiatrist this year, almost 3 years after the event, not quite fully 3 years. But clearly, this goes to show the truth of the statement that he gave to the police when he said that he did know her in his written statement to the police officers. So, my lords, in assessing his intention on this matter, you not only have the evidence of what he actually did at the relevant time, how he behaved, how he executed his plan, and how he avoided the police on the night in question. You have the following day when he was arrested, he gave a very coherent and reasoned statement to the police officers, and even more so to the point, if we are to look with any hindsight, to have any doubt whatsoever, we have it put beyond a shadow of a doubt when he says to the psychiatrist on the 16th of June this year that he actually had recognized her. And on that matter, Your Honors, it is my respectful submission that there is absolutely no merit whatsoever in the contention of my learned friend that the direction on this record is erroneous because the test on foresight of consequences was not put. It was not put, Your Honors, because it was not relevant in the circumstances of this case, and it was not appropriate to the factual situation and background that we have before us. And unless there is any other matter.
The question whether he knew the victim or not, was that a significant role in relation to the issues in this case?
Not quite, my lord, because the original plan was to rob someone. I don't think he would have planned to rob somebody whom he had known. But when, so his original plan was to rob anyone in order to get money to continue imbibing alcohol and perhaps drugs. So it just happens that this young lady came along, but at 40 he actually happened to have known her. So not only, so the fact of the matter is, my lord, it is not significant, but it's just happened like icing on the cake, in that he actually happened to have known her.
Yeah, it just seems to me that of course, it is relevant to credibility. Whether, he said one thing one time and he said another thing another time. But it didn't seem to me that there was any intrinsic importance attached to whether he knew her or not.
No, he only, as far as the evidence goes, in my respectful submission, he recognized her after the first stab that he inflicted in her buttocks. When she turned around, that is when he saw who actually it was, and at that point it was irrelevant because he'd already started to stab her.
Yes.
Wasn't the point that she recognized him after he stabbed her? That's what he says in his written statement.
Indeed, and he also said to the psychiatrist they both knew that they knew each other. The significance of that could well be argued that, having recognized his attacker, he decided that he will have to make a complete job of it. That's one of the inferences that would be open to any reasonable jury to draw in the circumstances. And maybe that explains why there were so many injuries he inflicted in order to conceal his identity after the attack.
But that issue was not an issue at the trial.
No, my lord. No, Your Honor.
I suppose it would be relevant would be that he wasn't in a sort of state of of autism, and that he was able to recognize somebody that he knew, and moreover, to recognize that she recognized him.
Indeed.
Which I suppose might be used as indicative of his mind functioning, with some normality at the time.
Indeed, my lord. And more to the point is the manner in which he behaved upon inflicting the injuries on the young woman. When the police car drove up, if he was on autopilot, so to speak, why didn't he run towards the police car? What he did, he actually avoided the police. He ran away and avoided escape and got someone to take him to his home. In fact, he returned to the shop where he cleaned up his boots with some of the liquor he was drinking at the shop and by wiping the blood off of it, and then he was taken home. So this is a man who was clearly in control of what he was doing, in my respectful submission, my lord. So unless there is anything else on that ground, thank you very much, my lord. The next ground argued by my learned friend is the issue of counsel error. My learned friend has made very heavy weather of the fact that Dr. Ramsey, who conducted this trial, one, did not give the accused a choice, that is, as to whether to go on the witness stand or not, as I understand his submission, and two, advised him improperly by putting him on the stand, and thirdly, not adducing evidence of diminished responsibility. That's the gravamen of his complaint, as I understand it. Well, if I must say, I'm confident that Dr. Ramsey, for whom I hold no brief, has been at the bar much longer than both myself and my learned friend. Dr. Ramsey conducted the case, I'm confident, based on his instructions that he has, which we will never know, or which we may not know, or which we do not know at this time. And certainly, it is unworthy to characterize the putting of a witness on the stand, an accused person on the stand, as incompetent of counsel. If we let the record speak for itself, Your Honours, the trial at about page...
I ask questions about Dr. Ramsey. I am afraid I don't know him. But has he been in practice for some time, or how long would he have been in practice?
A lot with the greatest respect. As far as I know, and I think he's much my senior, when he returned to Barbados from being ambassador to the United Nations, he has been at the bar since then. And that is since I think the late Tom Adams came to power, which was in like 1976. I'm talking about being hearing about Dr. Ramsey since I was at university. And he has been in constant practice. He's done several murder trials that I'm aware of. And he has always been at the bar. And as far as I know, he's never left the bar since about the 70s when he returned from the UN as ambassador.
Has his field of practice been in the criminal courts?
He has a varied practice with respect, my lord. And he almost, at every assizes, he does a matter, invariably. And he has done murder trials. He did the famous one, the body in the bathtub murder trial, where a very wealthy West Coast woman was killed, and the man was actually acquitted in that. And he has done several other murder cases. That one comes to mind. But he has been in criminal law practice, I think, I can say without contradiction, even from my learned friend, for the longest while. If I'm...
He has the experience, whatever else.
My lord, I would say he's well tried and tested. I was trying to find a point in the prosecution's case where the Crown had closed its case. I think it's 109 or thereabouts, and the options were put to Mr. Yes, it's 108, Lords, of the record of proceedings, which would be tab 6. 108, line 10. The clerk of the court. Tyrone Da Costa Cadogan, the Crown has closed its case against you. Now is the time for you to present your defense. You may do so in one of the following ways. 1, you may come to the witness stand and give evidence on oath, in which case you may be cross-examined. 2, you may remain where you are and make an unsworn statement, in which case nobody will ask you anything. Or 3, you are not obliged to say anything at all, and in any case you may call witnesses. What are you going to do? The accuser's response. Number 1, the clerk. Come to the witness stand. Dr. Ramsey. Yes, the witness stand. So there is no doubt from the record, my lord, that the accused man was given a choice in the presence of the court as to whether he wants to go on the stand to be cross-examined or not. And he chose to be cross-examined, and that's...
Yes, but I understand the point to be that Dr. Ramsey did not explain the alternatives to him and advise him with regard to them. But may I say that we really have no evidence of that. So I don't think you need take too much time on this, because apart from what Mr. Shepherd told us from the bar table, we really have no material on which to base a finding that a counsel failed in his duty to explain the alternatives and to advise his client with regard to them.
Much obliged. I take the point, my lord, and I'm indeed grateful. Suffice it merely to say, I'd say one thing. I would just refer you to that whenever this issue of counsel error arises, the Court of Appeal in Barbados, since 2004, has laid down guidelines as to how this matter should be addressed. And that guidance is found in the case of Mervyn Weeks, which is at tab 24 of your Lordship's bundle, of the bundle. And it sets out quite clearly that if you wish to argue counsel error, oh, not this one. Where's the other one? The case of Mervyn Weeks, I think it is...
That's not 24.
I'm sorry, my lord. No, would be one a little later. If I look at the index, I'll tell you. Tab 30, my lords, I'm so sorry. And it is at it's quoting Lord Justice Judge and at page paragraph 43 of that decision, my lords. I cannot see the pagination. It's paragraph 43 of the... In this case, my lord, a similar point was taken that counsel who had conducted this trial, I think it was a rape trial, defense counsel who conducted it was incompetent. The new counsel was retained, and point was taken that the counsel, similar things were alleged against him as is alleged against Dr. Ramsey. And the Court of Appeal rejected those and provided guidance in the 8-point plan here that should be followed in every case in which counsel error is alleged. A distinct procedure has been set out for this to be followed. And I may say that has not been done in the instant case, my lord.
Well, what is it?
The point, my lord? It's also, oh, I didn't intend to read
Could you
it. But,
just summarize?
oh, it says 1, from paragraph 43. Counsel should not settle or sign grounds of appeal unless he or she is satisfied that they are reasonable, having some real prospect of success, and are such that counsel is prepared to argue before the court. 2. When allegations are properly made, newly instructed counsel, in accordance with the legal profession code of ethics, must promote and protect fearlessly by all proper means his or her lay client's interests, without regard to those, including fellow members of the legal profession. 3. When newly elected counsel is satisfied of the allegations made and a waiver of legal profession privilege is necessary, the client should be advised fully of the consequences of waiver. Counsel should obtain a waiver of privilege in writing, signed by the client, relating to communications with instructions given to and advice given by former counsel. Fourthly, allegations should be set out in grounds of appeal and lodged with the registrar and the court of appeal. Fifthly, on receipt of the waiver and grounds of appeal, the registrar will send them to former counsel with an invitation to respond to allegations made by a specified date. Sixthly, former counsel may seek an extension of time for responding if necessary. Seventhly, it is perfectly proper for newly instructed counsel to speak with former counsel as a matter of courtesy before perfecting grounds of appeal. And eighthly, when there is a factual dispute between the client and former counsel, both may be required to give evidence before the Court of Appeal. It is axiomatic that cross-examination will be allowed. That's the guidance provided on the 30th of May, 2004, when this decision was given by the Court of Appeal. And that decision is predates what we are dealing with today. This procedure that has been adopted from the English case has not been followed. And what we have before us is mere allegations and attempts to vandalize the professionalism of one person without giving the person a proper hearing when there is a procedure for that.
Scandalize?
I said vandalize, my lord. And I don't think it's appropriate in the circumstances when you have guidance as to how the matter should be pursued. Suffice it to say, my lords, if I will leave that matter there, unless you wish to hear me specifically on anything else with respect to counsel's error. Suffice to say that the provision that has been well established in the laws of Barbados for this matter to be reviewed and dealt with has not been followed. That brings me, my lords, to the third ground.
I think one of the criticisms that was made was that council ought to recognize the need for a psychiatric report. Since his options in terms of its client's defense were so limited, and it came down really to the mental element. Ought he to have taken some steps to have psychiatric examination? That is one directed to his state of mind at the time of the offense.
Indeed, my lord, and I thank you for reminding me of that. My lords, the point is, as at this date, we do not know what the instructions of counsel were in defending this matter. What we do know, or what we can gather from his instructions, and what is the nature of the cross-examination and the defense that was mounted by the accused when he took the stand, giving sworn evidence. And this being a court of record, we are all bound by the record. Suffice it to say that what Dr. Ramsey would have presented before the court as his defense is what he, honestly, I can only say, in light of the presumption of regularity, would have been instructed to do. There was it is not evident anywhere on the record that there was any disagreement between counsel and his client during this trial.
That
there was any disagreement between them, that counsel was not putting forward instructions or asking questions that he should have. The good thing about these records now is that they even carry sort of voces sometimes that we say you have to be so careful. And this record does not show that there was any disagreement whatsoever, and that's what we are bound by. If we have to go outside and speculate as to whether or not there should have been a case of diminished responsibility, what would have been the report of Dr. Bell, which, if my information was given to Dr. Ramsey? It simply says, I've examined Mr. Cadogan on such and such a date, he's fit to plea, he's fit to instruct counsel, and he's fit to stand trial. That's usually the initial psychiatric evaluation that is done by the police in Barbados. In every capital case, they're obliged to do that, not by law, but by good practice, and that is what has been done. So that is what that report says. That is what would have been given to Dr. Ramsey, and that is what is done for every case. And if there was any basis at all on which there could have been a case of diminished responsibility, I'm confident it would have been pursued. It was not being pursued, my lords, and it can only be speculation at this stage whether or not this exists. But more to the point,
do you know of any cases in which I call them government psychiatrists for want of a better description, have given evidence for the accused?
My lords, I cannot conceive of any situation in which calling a government employee, whether a government medical practitioner or a government psychiatrist, can be considered any derogation whatsoever. That person has his professional reputation and his professionalism to go by. And it has been the practice in Barbados that in these situations, as was stated quite in my response, what the practice is. If there is a need for a government psychiatrist, the defense are always entitled to request the psychiatrist, to examine the patient. Psychiatrist cooperates, provides an examination, he comes to court or she comes to court and testifies. All of that is considered within the scope of his or her duties. And that person will not give any lesser quality of evidence because he's employed by the government. In fact,
well, I'm not imputing their professional integrity, but I am curious as to whether, by virtue of past experience, there may be some grounds on which defense counsel take such a pessimistic view of their chances of getting a favorable report from a government psychiatrist.
Well, it is my respectful submission, my lords, that such a view is wholly misconceived, because even the very Dr. Mayhew, who has now given the report, as my learned friend said, at their expense, he used to be one of the leading government doctors also. I don't know if he's retired now or what, but I mean, people are in the government's employ on contract or what have you. For all you know, he might still be in the government's employ on contract. I don't know. But the point is, my lord, that's been the practice in Barbados, that the psychiatric evidence is provided by the doctors at the psychiatric hospital, and it's all publicly funded and paid for. And the doctors have always cooperated, and there has never been an issue. The similar argument was taken in another case we had before the Privy Council, the case of Arlie James. And it's the same answers that we provided, and Privy Council were quite happy to accept that if, notwithstanding the fact that they are in the government's employ, they are obliged to provide proper evidence. And if the law and the Constitution does not, what my learned friend is seeking to get this court to agree to or to order, is that to provide funding for a psychiatrist of their choosing. That is a totally different thing.
But excuse me, Mr. Leacock, I don't think you have actually answered my question.
I'm sorry, Milo?
I take it you have experience of prosecuting, and I was asking, let me put it rather differently, whether in your experience in a criminal case, the psychiatrist employed by the government has ever given evidence that would support a defense of diminished responsibility.
Oh, decidedly, my lord.
I'm sorry?
Decidedly.
Yeah,
Oh, I mean, once they're examined, and if there was such evidence, I would be the first to offer them manslaughter on the grounds of diminished responsibility.
Yeah.
So, I didn't understand your question first, brother.
Sorry, Mr. Leacock. Do you know of any specific case? Can you recall any specific case where the defense psychiatrist, so to speak, was employed by the government? Or had some employment, some part-time or other?
As far as I know, almost all of the cases that are done in the courts are done by psychiatrists who are attached to the... Dr. Bell is the consultant psychiatrist, and she gives evidence for the defense in almost every case. I'm trying to think very hard if there's any psychiatrist outside of the employ of the government who might be in so-called private practice, but I cannot think of any. If my learned friends could think of any, they can certainly let the court know. But as Dr. Bell is the one who comes to court most frequently, and if her evidence, or somebody from Dr. McLaughlin, or there are a few others now, at the psychiatric hospital, and if there is any basis that the accused is acting strangely or psychotic, the prosecution is the first to offer them manslaughter on the basis of diminished responsibility. In this case, as the public prosecutor, I could not do that because there was no legal basis for me to do that. I hope I've answered the President's question now. So,
well, you say it's quite a common occurrence for that to happen. And I understand you.
It's absolutely routine.
Yeah.
It's routine. And if they tell us, well, this man really is not up to scratch, we're the first to say, well, okay, that's it. We accept, because there is no property in a witness, my lords. So when the expert, especially in expert witnesses, so even if we call them and they say, well, okay, the man was suffering from paranoid schizophrenia at the relevant time, we say, okay, unless we wish to impugn him. Dr. Patricia Bannister, who's now deceased, she gave evidence like that all the time, and we accepted it. And because she's the expert, we recognize her as an expert. If the defense recognizes her as an expert, they always do, and that's how it's done. So there's no property in a witness, not because she works for the government or she's funded by the government. It means that she does not have her professional integrity first and foremost, my lords. To say anything otherwise, in my respectful submission, would be erroneous.
It may be on this Leacock's matter, of course, entirely for you, but it does occur to me that there may be cases in which it might be as well a good idea for you or your department to take the initiative in having a person psychiatrically examined with regard to their culpability and for the offense, particularly in murder cases. It would operate even as a sort of defensive measure, in that it would put you in a better position to resist any application like the present one. But also, and more importantly, it would serve the interests of justice if there was a genuine case of diminished responsibility or insanity, which you could, winkle out in that way.
I fully agree with you, with you, my lord. And but as I said, that is actually mandatory, as if somebody is charged. A mental
not on the examination done as to the fitness plead.
But it is not necessarily confined only, my lords, to the fitness to plead. We do not tell the psychiatrist what to examine. The man is, or the person is taken to the psychiatrist.
What is the purpose for? Is the psychiatrist told of a particular purpose for this particular examination?
Well, it's just to ensure that the issue of sanity or mental fitness is clear before we put anyone on trial.
Right. So that then the psychiatrist would be looking at the person from the standpoint of the person's mental state at the time the psychiatrist examines the person, and not necessarily at the time of the incident.
Well, my lords, the two things are almost intertwined, because as soon as the person is charged, they're taken, even before they make the first court appearance to the psychiatrist. It's done that early. So that in almost every case, I cannot think of anywhere I can recall it was done after the first court appearance. The day if the man is charged at 2 o'clock today, they are almost obliged to take him today by within 3 o'clock or within a very short time. But before his first court appearance, he has to be taken under that practice to see a psychiatrist. It also helps us with another thing too. It helps the entire criminal justice system with another thing. Let's say he decides to allege beatings or something. You say to the psychiatrist, it goes down on the record. It's all there. Because you are seeing a doctor immediately after
Dr.
you've
Bell
been
examined this applicant.
Dr. Bell did examine him.
Why didn't you make available to these current counsel Dr. Bell's examination?
My lord, my learned friends wrote me on Friday afternoon at about 4:30. I saw on the fax, and I saw it Monday afternoon, just when I was leaving here. But more to the point, that's a memo I sent to them because I knew the nature of the disclosure argument. So I made my letter available, which was information to the Commissioner of Police over 2 years ago, 2004. And that information, from my information, was given to the defense counsel at the trial. I conducted the trial and appealed also in the appeal in this matter, and there was no issue from Dr. Ramsey as to whether or not this matter was ever shown to him. I got that letter. It was dated about 4:30 on Friday afternoon. And when I got to my office on Monday, I didn't stay very long in my house because I don't even have the police file at this stage. So there's no way I could physically give him Dr. Bell's letter.
But you have Dr. Bell's letter.
I don't have it. I will get it from the police.
But have you seen it recently, or are you aware of its contents?
Well, I would have seen it in 2004 when I did the trial, and that is usually a standard thing. If there was anything different, accused examined on such and such a day, fit to plea, fit to stand trial, no psychotic illness. That's the nature of what they all say. And that is what is passed on to the defense. If they wish to probe it beyond that, they probe.
As far as you recall, there was nothing in that report letter which might have assisted a defense of diminished responsibility?
Absolutely not, because I wouldn't wait for that. I would tell them, in light of what I have here on this file, I'm offering you manslaughter on diminished responsibility because there is such a basis for it. Of the 25 murders or so per year in Barbados, only about 2 or 3 end up in convictions of murder. Most are manslaughter cases. So, unless I can be of any further assistance on that matter, my lord.
No, you can go ahead.
May I, with your leave, proceed to ground 3? Facilities. My lords, my learned friend's complaint here is on the Community Legal Services Act. He's raised a number of interesting thoughts under this act, and as to one, whether or not the police should tell people of their rights to legal advice or legal aid even before charge. And two, he cites a number of Canadian cases, Bartle and Posnia, the drink driving cases, in which the police in Canada were obliged under their rules to tell the defendants of their rights to the free duty solicitor. And then he also argued that there should be the legal aid funding of about $5,000 is much too low, and that persons on capital charges should be entitled to self and another lawyer. Much of these, my lords, are policy matters. But if I may address the legal issue, as regards the law in Barbados, the Constitution, Section 1812, specifically says that there is no entitlement to publicly funded legal representation. You're entitled to a lawyer of your own choice, but nothing in the can be read to construe that to mean that it must be a lawyer funded by the public. This matter is seriously canvassed by my learned friend at the Privy Council, and in a seminal judgment of Richard Hines, which is the Privy Council dealt comprehensively with the matter. I can easily refer.
What was the decision?
Pardon me? The year?
Yeah, what's that decision?
My lord, it was in 2002.
Hines?
Hines, Richard Hines. Yeah. It's in the bundle. What tab is it? Or it's in my bundle. Which one?
29.
Thanks. My learned friend has very helpfully told me.
29 in there.
Thank you very much, my lord. It's not. I'm sorry, I don't have all these tab numbers correctly, but my lord, this is a case in the context of an arson trial, where a man Mr. Hines was charged with arson. He had set fire to the house of his former lover, and in fact somebody had died. But this related to arson. Mr. Hines went to court and applied for legal aid, and it was refused by Watman J, who now sits on the Court of Appeal. And my learned friend sought constitutional redress for the failure to provide legal aid on the basis of the same arguments he's put forward here, that it should be publicly funded and that he should be entitled to relief under the Constitution.
Mr. Leacock, are you saying that doesn't matter what the charge is or how complex the case is, but the denial of legal aid can never support a challenge of a conviction?
Far be it from me, my lord, to suggest anything as that.
I was wondering, you see, as to whether you interpreted the provision in the Constitution, which you just read, as having that effect, or whether you would give it a less far-reaching interpretation.
No, my lords, with a great respect, we live in 2006 and we're far more conscious of the rights of people. And the Constitution, in its wisdom, which was drafted some 40 years ago, did say that nothing can be construed as compelling the state to, but the state, by enabling legislation, the Community Legal Services Act, have provided a scheme and a system as the Parliament, by enabling legislation, the Community Legal Services Act of 1981, has provided a scheme whereby it's provided. So certainly provision is made, and I do not interpret the Constitution in such absolute terms with the greatest respect, my lord. That you can have legal aid in an appropriate case.
Yes.
Because
this is simply hypothetical, but if, for instance, in this case, this accused had been denied legal aid so that he had been unrepresented, then the conviction could not be stand, could it?
Lord, as long as that would never happen on my watch as the director.
Well, I thought that's not the point. you all watch like mine is finite.
That it wouldn't happen on our watch.
Oh, but come on.
Couldn't happen. Couldn't happen. Because, with the greatest respect, this is too serious. Look, there are a number of scheduled offences, including murders, rape. I'm not going to list them; they're all there. And in the instant case, this gentleman the applicant was actually represented from the preliminary inquiry, which we still hold, the old style ones, right through to the trial and to the Court of Appeal. He was fully represented by counsel throughout, and there could be absolutely no issue about that. But what I wish to draw to your attention, well, apart from the law, I don't think I need to take you through the law. It's all stated here what the Privy Council has said about it. Suffice it, maybe I should draw your attention just to one aspect of it. I think it's around page 11. It's page 12. If you look at page 11, paragraph 15, if you just indulge me, I'll read a little about half a paragraph. Page 11 of the judgment, paragraph 15. In the opinion of the board, that's the Privy Council, these conflicting submissions raise issues of considerable importance. The Constitution is to be read not as an immutable historical document, but as a living instrument reflecting the values of the people of Barbados as they gradually change over time. That answers your learned president's question as to how we interpret the Constitution. But the courts, including this board, as a final court of appeal of Barbados, must give effect to its terms. Section 18(2)(d) protects the rights of criminal defendants to defend themselves before the court, either in person or by a legal representative whom he has chosen. But this right is to be interpreted in light of Section 18(12). Such a defendant has no entitlement to professionally represented at the expense of the public. This subsection is not directed to the choice of representative, but to the responsibility for paying for the representative chosen on the Section 18(2)(d). It is a provision including to avoid doubt. And then it goes on to say what Barbados has done in relation to when it's acceded to the various international conventions. I've simply said that, my lord, to show you that the Barbados has actually provided statutory regime for the provision of legal aid. And in this case, the matter is only academic in my respectful view, because this gentleman was always represented from the preliminary inquiry right through to the Court of Appeal.
But I think, Mr. Lee, I thought he was saying that even before charge,
yes, I'm coming to that.
He has, I don't know whether you're saying legal aid entitlement or entitlement to a legal aid lawyer, and that this should be announced to him as a part of his rights, so to speak.
Yes. What my learned friend, as I understand his submission is, he relied on two Canadian cases, Bartle and Pontiac, the drink driving cases, where particularly Mrs. Pontiac was arrested for not driving under the influence, and she had to be subjected to breathalyzer, and so it was incriminating evidence and what have you, and so she should have been told of the provision of the free duty solicitor. I must say the reality is in Barbados we do not have a free duty solicitor. We have a provision for legal aid where you are assigned a counsel by the court or direct application to the Director of Legal Services, and you get a counsel at your trial. nowhere in our law does it provide for you to be informed of a free duty solicitor, because that doesn't exist. What our law provides for, however, is that upon arrest, the police must inform you of your right to legal advice, and that of your right, that you have the right to contact counsel, and that right must never be impeded, because we've applied the Whiteman case arose from this country that went to the Privy Council, also Ali Muhammad, and we also have our own local case of Chase, in which that same point was fully discussed. So the police are under a duty to inform you of your right to counsel, and that was actually done in this case, my lord. If we look at the evidence of the police officer in giving evidence, it was around page 38 or thereabouts. Page 39 of tab 6, my lords. You will forgive me, I still haven't gotten the language right, but I'm working on it. If you join me at page 39, if you look at let's say line 20, this is the police officer giving evidence. Tyrone Da Costa, after he was arrested, this is when he was arrested the following day after the incident. On arrival at Central Line 18, on arrival at Central Police Station, Central Criminal Investigation Department that night about 7:10, I told Tyrone Da Costa in the presence of Constable 1430 Roach that I intended interviewing him in connection with the murder of Paula Crawford, and that he has a right to an attorney at law and to hold private communication with him. Tyrone Da Costa replied, I don't want no lawyer. I will talk to you. My lords, this is the practice in Barbados, and this is what was faithfully followed. That upon his arrest, when he was taken to the police station, he was told immediately of his right to counsel and his right to free legal advice. Not to legal advice. We do not have free duty solicitor services, and maybe it would be something for the future that we should have indeed. But those are matters of policy that I cannot, as a humble director, cannot address before this honorable court.
I think Mr. Shepard's submission was that the police should have been more active in assisting him to get legal advice.
I understand that point, my lord, but I fail to see how could they assist him more than what the record said. This is when he was, if we look earlier on the sub-page, from line 5, the witness is testifying again. At 18:45 p.m. on the 9th of December, as a result of information received, I went to the Church of the Nazarene, Bank Halls Road, St. Michael. I was accompanied by Constable Roach and other officers. We were dressed in place. On arrival at the church, I saw the accused, Tyrone Da Costa. So here it is, the police saw him at about 18:45. He voluntarily went to the station with them, and they immediately told him at 19:10 or thereabouts about his right to counsel. With the greatest respect. With the greatest respect, my lords, I think the police have done all they can in the circumstances that they, in light of all the facilities and their legal obligations, as was possible, as page 39 of the record reflects. And I cannot agree with my learned friend that they should have done more, because there's nothing more, in my respectful submission, that they could have done in the circumstances.
Right.
The other issues, my lord, about the inadequacy of $5,000 and the 2 silks, I really cannot address you on, because those are matters of policy. Suffice it to say that this counsel who represented Mr. Cadogan, that's Dr. Ramsey, has been at the bar longer than both myself and my learned friend.
Is he a senior counsel or Queen's counsel?
Not the last time I checked, my lord. I do not think he's a silk, if that's what you meant.
Yes.
I do not think so. But he is certainly very well known at the bar, and he, as I said, he has a very colorful career as an ambassador to the United Nations, and he has been back in even sometimes in politics and what have you. If therefore, with your lordship's leave, I may leave that ground on the facilities, unless you wish to hear me on any other matter. Thank you, my lords. I will then proceed to look at the issue of diminished responsibility. And I must say, on the question of facilities, my lords, I have set out my arguments as a respondent's case, and I do adopt all of what I've said there in my arguments so that I don't have to repeat them here. Diminished responsibility. On this ground, my learned friend Mr. Cannon takes the point that diminished responsibility was an available defense and should have been left by the trial judge, who should have drawn it to the attention of the jury or to counsel. The first rule of law, as I understand it, my lords, is like provocation in the case of Accord. It says for a provocation to be left, there must be an evidential basis. For any defense to be left, an affirmative defense to be left to the jury, there must be an evidential basis upon which that defense has to be left. And if there is no defense if there's no evidence of insanity, for example, and a judge leaves insanity, one of the first grounds of appeal, if I were defense counsel, would say that the judge has confused the jury by leaving matters on which there is no evidential basis. And I'm sure anybody else would do that. In this case, my lords, there was absolutely no scintilla of evidence for diminished responsibility. They report, even the very report that my learned friends now seek to have introduced, that of Dr. May, does not support a conclusion of diminished responsibility. Because to establish diminished responsibility, one must show that there was there was an abnormality of the mind, and two, the abnormality was so substantial as to impair his mental capabilities. On both counts, my lords, this affirmative defense that my learned friend seeks to put forward has failed. Because there's no evidence of an abnormality of mind, even the slightest. And secondly, there is nothing to go anywhere to show that it was substantial or otherwise that this man was rather normal.
What about this personality disorder? Would that not fall into the category of abnormality of mind?
I didn't hear the first part.
The personality disorder.
Oh, personality disorder. Well, in order to say that there is a personality disorder, one would need some empirical evidence for that. One would need an assessment, and one would look, and from the past cases I've done, to see what is the history of the man. In this case, there is no evidence that I can see to suggest anything of a mental nature. The applicant himself has denied any mental illnesses whatsoever. A personality disorder is purely...
you speak as a layman or as a person with some knowledge of this field?
Only to the extent that I have had to cross-examine lots of psychiatrists in my time, my lord, and I think I tend to know what to look for. But certainly I have no training in psychiatry or psychology to profess to give an opinion on this. But suffice it merely to say that you will have to have some evidential basis, namely a history of it, and or some sort of symptoms that would be reflective of that kind of behavior, or maybe even a family history of it. What we have here is a narrowly construed interview done almost 3 years after the offense by a doctor who apparently, I don't know even if he looked at any history, family history, but nothing like that is suggested in the report. The only history we've seen in the report is the fact that the accused is denied any kind of mental illness. So to conclude that it was a question of that there is a personality disorder, it's a matter of...
I don't think that is quite fair. I think that the passage which I read this morning does set out some of the man's history. which the doctor had got from him.
Yes. And that's correct. She was aggressive at school, and he was recalcitrant, and he was a bit stubborn in his ways,
But the lifestyle,
and a lifestyle of drugs and alcohol. Yes.
see, he has his account of his lifestyle suggests that he had a personality disorder. And is the lifestyle described in the opening paragraph?
Indeed.
Is that his lifestyle? Perhaps.
Yeah. He was very calm, cooperative, and polite, and his answers were always appropriate to the questions put to him. He was well-oriented and denied ever having any features of a psychotic illness like hallucination, delusional systems, or gross thought disorder. Indeed, my lord, it is. I fully take the point that what you're seeing here is just very tragic to say sometimes, is the way some people do conduct their personal affairs. They imbibe alcohol, they take drugs, and they live in this way of where he said his girlfriend stabbed him and what have you. They were involved in frequent physical and verbal fights. But that doesn't necessarily mean that because he's that these things are symptomatic of a mental illness for which he's never had any kind of treatment and for which he vehemently denies with the greatest respect. And I would say that Dr. May's visit report being predicated on simply one visit and in a very charged atmosphere in which a man is under a very serious sentence can lend itself to that sort of conclusion rather impetuously, because there is very little to go on. As I said in my response, it's very narrowly based, and I honestly think so, in light of the circumstances that the doctor has seen him so long after, and to give an opinion as to how he was as at it was the 8th of December or whenever this offense occurred. It's a very long shot to take. It's almost in the I couldn't say that, but it is very narrowly based and rather subjective. And I don't think in any event, if this were to be left to a jury, that they would act on it. Because as we know, even the case of Walton that is in the bundle, where we have another appeal from Barbados that went to the Privy Council, where psychiatrists, a clinical psychologist, and the medical practitioner give evidence saying that the man had a personality disorder. The facts of that case, my lord, is where some people were at the races in Barbados, the Garrison Savannah, and they had a quarrel with the accused. He stopped the car, they came out, they stopped the passing car and got into the car. He came over to the car, spoke to them, and shot one of them, and the passenger in the car died. And the psychiatrist in that case had said that he had a personality disorder also. And that went to the jury, and the jury rejected it. Not only the psychiatrist, but the psychologist, as well as the medical practitioner. And that is in bundle. I didn't bother to cite it, but it's Walton.
You're getting on dangerous ground, you know.
No.
That case really underlines how important the verdict of a jury is on this issue.
Yes.
And I think that is what the applicant is saying to us, that they're entitled to have the verdict of a jury on it, because they haven't had it yet.
No. Well, with the greatest respect, my lord, I was seeking as best I could to refine or to put the parameters on personality disorder and to illustrate how it has actually been used. But suffice it to say that on the instant case, I honestly can say, would submit that there is no basis for any finding that there was any mental illness on this man to ground an affirmative defense of diminished responsibility. And in the light of the evidence in this matter, when we look at the conduct, which is the greatest test, in my view, of the reality, of the actualities of the situation here, is when we look at the conduct of the accused immediately before, during, and at the time of the killing, we can only find a man who is fully accountable, who is fully aware of his actions, and who is responsible for his acts. And in those circumstances, the Court of Appeal, having reviewed this matter very thoroughly and examined all of the case law on the question of intent that was put before it, it is my respectful view, my lord, that there is no basis or no leg on which this defense, this affirmative defense of diminished responsibility could stand.
Mr. Leacock, do we not have to apply the Act on fresh evidence, the relevant Barbados provision, in deciding, first of all, whether we treat this evidence as credible, and secondly, that there was a reasonable explanation for not having put it forward at the trial? Do we not have to deal with that first?
Indeed, my lord. I hadn't even gotten there. I was just responding to the questions that were put to me. But in fact, before you can even get there, this is all considered fresh evidence. This will have to be considered fresh evidence, and it will have to comply with Section 29 of the Criminal Appeal Act. And it does not comply with any of the provisions. And in my response, my lords, I have set out quite fully the arguments I adopt here in my written responses as to why it does not comply with anything in Section 29 of the Criminal Appeal Act. Because even if this evidence exists, Dr. May and the applicant were always in Barbados at all material times. There is no reasonable explanation as to why this was not produced. It was not even raised at the Court of Appeal level, and it was not even, and to raise it now is simply to seek to provide another ground of appeal for one that had never really existed, and that when the one that was tried, having been rejected, you now seek a different horse on a different jockey, if I may use an equine analogy. But I cannot see how this can comply with anything that the law requires of us to look at, to consider fresh evidence. And I've also cited to your lordships the case of Malcolm Ford, which is in very similar vein to this, a decision of the Privy Council, where affidavits were sought to be produced that somebody else had committed a murder, and it was not the accused. It was held to be incredible, incredulous, and was available always, and therefore it was not admissible. So even so, my lords, it cannot get past Section 29 of the Criminal Appeal Act in its most liberal and widest connotation.
I think the other side is putting forward the ineptitude of counsel and the indigence of the accused, of the applicant, as their reasons why it was not put forward before.
My lord, with the greatest respect, those are wholly misconceived, because the indigence of the accused has nothing to do with putting forward the defense of diminished responsibility, as was explained how the law works in Barbados. You're entitled, and he was entitled and had that access available if he wanted to that. If he didn't choose that, then he chose to go down the road based on the instructions that counsel had gotten. We have nothing that counsel has violated explicitly, any instructions he was given. And therefore, I cannot go second guessing counsel as to what he did in the circumstances. So the indigence point, my lord, with the greatest respect, cannot avail, because the psychiatric facilities are always available to everyone. And as regards the question of incompetence of counsel, I can only best answer that by referring to what the Court of Appeal in Barbados, through the decision of the now Governor General, said in a similar case, the case of Tennyson Griffith. The 7 persons were convicted of murder for the first time in Barbados. It's tab 33, I think. Oh, there's no. Is there a tab 33? No.
Tab 24.
Thank you very much, my lord. I'm really sorry about getting these tabs so wrong. This is quite a case that this conviction was of 7 persons, and it was affirmed by the Privy Council eventually when they decided on whether or not the felony murder rule was constitutional. And if you look at page 63 of this decision, page 63, my lord, of the decision on tab 24. If you allow me to read from page 62 at the bottom, that will put the whole flavor of the thing in context. Page 62, the last paragraph. It was a similar case in where affidavits were being sought to be introduced at the Court of Appeal level to say that one of the appellants, Victor St. Rose, was illiterate. And this is what the court said about it. Against the background of testimony by police officers, especially the unchallenged evidence that the appellant was doing a crossword puzzle at the Criminal Investigations Department, and the coherence of the appellant's unsworn statement from the dock, clearly the evidence proffered, lacking as it is in credibility, is not admissible under subsection 2, as of section 29, to ground the claim that the appellant was illiterate at the relevant time. Further, the proffered evidence was available at the time of the trial, and there is no explanation, reasonable or otherwise, for the failure to adduce it, save the assertion that counsel at the trial was incompetent. It resonates very well with what we're hearing today. Far from being incompetent, we think that counsel at the trial is to be commended for not acting as a mere mouthpiece for a contention that was not supported by evidence and was totally without merit. And then they discussed their discretionary jurisdiction under that, and they went on to say this. That same paragraph, after citing the case of Ford that I've referred to, my lords, this is what they said. A few lines down. Underground 7A, here with me. Same paragraph, just on the Ford, 3 lines on the Ford. Underground 7A, there is no evidence to support the particularized allegation of incompetent or inefficient advice or representation. And underground 7D, the request for a voir dire in the presence of the jury and the failure to call witnesses in that regard are tactical options which counsel who has conduct of the trial must in his discretion be free to exercise, having regard to the evidence and his feel of the case. And I think, my lords, I can put it no better than that. Because counsel cannot be criticized for doing one thing when that was his call after his instructions and his consultations with his client. To come now years after, by hindsight, to say because this was not done, you were incompetent, I do not think it satisfies the test of incompetence whatsoever. You're seeking to have 2 bites of the same cherry, and it's not appropriate in the circumstances to do that. And this, I think, is the best way in which it has been put. And this is how I would respectfully submit that this honorable court should actually resolve the issue. There was no scintilla or factual basis to support the contentions of counsel's incompetence because he didn't have a voir dire on the statement. And if you wish, I can give you my views on that, on the law, on the voir dire as it came up, or if you wish, and in those circumstances, I would submit there is no merit in this contention.
What do you say about the voir dire issue?
Yes. Lord, my learned friend might have been correct when he said in the late 70s and 80s, there was some kind of confusion in the court as to when a voir dire is held. But with the advent of a JODA, and I must say I don't have a JODA here with me, but with the advent of a JODA, the law has been conclusively settled as an appeal from Trinidad and Tobago on this matter, where the court has set out 4 propositions on which a voir dire is held. And the first one, I wouldn't give you them in order, but once there's an issue of voluntariness, once any allegation is made that the statement was not voluntarily given, a voir dire is held. Secondly, if on the evidence as it stands, there is some indication that the statement was not voluntary, a voir dire has to be held. However, as I recall quite clearly, the full proposition in the JODA, JODA is 1981 to All England Reports, page 193. At page 202, I think it's paragraph H, I don't have it, but I always cite this to the court when I'm on my feet. Page 202, paragraph H, I think it is, the full proposition says that if the defense is that it's a complete forgery, that is, the man is saying, I never made it. I don't know anything about that document you're seeking to produce. In that case, that does not raise an issue of voluntariness. That is a question of fact, and the statement is put in for the jury to determine what weight it has. And that is my understanding of the fourth proposition. So no voir dire has to be held in that circumstance because the defense is a complete denial of the statement. He's not saying, I signed it, but it's not what I signed, like the non factum plea in contract law. He's not saying I signed it because of force that I was beaten and tortured to sign it. He's not saying I gave this police a statement, but what I signed is a totally different document that they brought to me. He's not saying that. In the case, in the fourth proposition, where he's saying, I know nothing about this. I never signed this. I never gave you the words that are recorded in it. It's a total forgery the prosecution is seeking to produce. In that case, there is no voir dire, and that is the fourth proposition.
I'm grateful for your support.
I am thankful. I would consider myself rather honored to be in such company, my Lord. In conclusion, my Lord, it is my respectful submission that the application for special leave in the instant case should be refused. No arguable issue or triable cause has been raised before this court to put this court to open this matter. This matter has been fully ventilated, and the application for special leave should be denied for the reasons that are given. Namely, the judge was not obliged to leave diminished responsibility to the jury as there was no such evidence. Secondly, there is no evidence of counsel's incompetence because he chose a different tactic that other counsel might not have chosen. That is not a basis for submitting that that someone is incompetent. Thirdly, the evidence of Dr. May does not constitute fresh evidence and falls afoul of Section 29(2) of the Criminal Appeal Act of Barbados. And fourthly, the Constitution does not mandate that legal aid or funds be provided for the accused to choose a private psychiatrist. Psychiatric evidence is freely available and has been available in every case to indigent defendants. And if the accused chose not to use those facilities, it cannot lie in his mouth to complain that his indigence has prevented him obtaining a fair trial, because he never sought it and it was always there and nothing has been denied him. Fifthly, the Court of Appeal has fully cogitated on the matters of the law on intention. I cited all the cases to the Court of Appeal at that stage, from Smith to Woolen, and they had a full review of the law, my Lord, and that decision, in my respectful view, is correct, because this facts of this instant case show that it was a direct attack upon a person in order to obtain money, and it was not a case in which foresight of consequence direction is appropriate on the factual situation. And sixthly, my Lord, the decision, I said, of the Court of Appeal is right, and there is absolutely no miscarriage of justice in this case. The accused is not without remedy. Beyond this, should your lordships dismiss the application of special leave, he has the entire penalty of the Lewis decision to seek to have the sentence dealt with by another place at another time, I'm sure, on another occasion. Unless there is any other matter you wish to hear me on, my lords, those are my respectful submissions.
Well, thank you, Mr. Leacock.
I am much obliged, my lords.
I don't know if Mr. Shepard wishes to say anything.
I do, Your Honor.
Yes.
I will be very short.
Yes.
Your Honors, I have to say I was very heartened by the learned director's final statement, because it seems it seems to me that he's not at idem with the with the submissions made in the other matter. Anyway, my lords, first of all, the Weeks case. If I can say very quickly on that, the Weeks case refers to a procedure which is applicable when one seeks to challenge counsel's conduct of the trial in the Court of Appeal, and calls for the role of the Registrar of the Supreme Court in relation to sorting that matter out. This is, first of all, I don't know whether it would be applicable in circumstances where one is before the Caribbean Court of Justice and the registrar is a different registry, firstly. Secondly, I think it would come into play, if at all, in the event leave was granted. And thirdly, I think that the reason for the directions was really to set about some orderly way in which an issue of counsel's conduct of a trial could be sorted out. I sought to do that in a way in which I thought was the best way possible, in that everything that I did was copied to Dr. Ramsey, and I asked for his response. Given Dr. Ramsey's initial response to me, I was placed in that, I said, in a difficult position. Now, in relation to the psychiatrists and the disclosure point, I am sorry, my lords. I'm sorry, my lords, but I do not have copies of the correspondence available for your lordship. However, I am going to make available to your lordship. My learned friend said that it was only on Friday of last week that he received a request from me for disclosure. This is a letter which is dated the 18th of September, addressed to the director. And I ask your lordships to note that I asked for his assistance in relation to a number of matters. First, 18th of September, the notes of the proceedings do not contain any record of what either Dr. Ramsey or you said at the hearing by way of an address. I'm wondering whether you have any notes. It is particularly of interest to me, so on. 2, I am concerned to discover what comments were made in relation to the evidence of the accused to the effect that it was Oscar who suggested the robbing, taking the weapon, and that his statement was incorrect given any record does not show. This again relates to the addresses. 3, I am trying to obtain my client's file from Dr. Ramsey, and I understand he may not be available until early next week. In the circumstances, I would wish to know whether Dr. Ramsey made any application for unused material, and if so, what, if any, was the response? In any event, even if Dr. Ramsey made any such request, I would wish to make it now, and ask it to make available to me any unused material, or in the alternative, indicate that no such material exists. I remind you, and then it deals with. So there was clearly a request for the unused material, which was identified by the learned director in his letter to the police, namely Dr. Bell's report. This is the response that I received from the DPP, and I received it, my lords, bring it down, on the 19th of September, the following day. Enclosed, please find the case for the respondent opposing the application for special leave. The matter is set down to the 3rd. As regards your facts 18, matters relating to legal aid, as you know, are for the Director of Legal Services. Moreover, the appeal transcript is a record in these proceedings. The Department cannot assist you with any further requests beyond the record, as there is no note. And that is the response I got on the 19th. Since then, Your Honours, I made attempts to obtain material from Dr. Ramsey, and I was not given it. Now, Your Honours, it is, and I continue to say, it is my understanding that Dr. Bell's assessment is only on fitness to plead, and I do not accept the learned director's submission that it is the same. There will be occasions when the crime is committed months before the arrest,
I thought that you were saying in this particular
case. But the point is that
so close that it is immaterial.
I do not agree that when a psychiatrist is seeing somebody for the purpose of assessing whether they are fit to plead, they are in any way addressing what his state of mind was at the time of the offense. And in fact, persons are fit to plead who are later on acquitted either by reason of insanity or indeed by reason of diminished responsibility, and they go to trial. That is what we understand the Dr. Bell is. Now, the learned director did refer, I think, in answer to a question that was posed by Your Honor, Mr. Justice Lavassie, about the psychiatrist. I have to say that in all of the cases that I have dealt with, and I again will stand corrected if I'm wrong, you had Dr. Bannister and Dr. Mayhew. Dr. Bannister was mentioned in some of these cases as being attached to the mental hospital, but she was also in private practice. And so are the other doctors. There are doctors who have private clinics and are attached to the psychiatric hospital. Those are not the doctors that we are referred to. We are referred to the doctors who are in the full pay. Dr. McLaughlin, I think my learned friend mentioned. I am unaware, and please, I have to say that I am not, as it were, in the trenches, but I am unaware of any case where a doctor who was in full-time employment at the psychiatric hospital gave evidence for the defense. It may be that it has happened, but I am unaware of it. In the Hines case, Your Honours, I am not going to take you through Hines, but I am familiar with it. It is a case in which we sought to argue that the Hines was entitled to a simple declaration that he was entitled to a funded attorney at law for his trial. We argued that what had happened in Hines was that he was unrepresented at trial. He was represented before the Court of Appeal. And before the Court of Appeal, the point was taken on lack of counsel. Court of Appeal dismissed the appeal. And in those days, given the lack of access to our highest court at that time, except in murder cases, we chose to launch a constitutional motion to try and at least sensitize the court as to the need for counsel. If one looks at the Hines case, there is a provision in Section 18 of the Constitution which simply says that you're entitled to legal representation of your own choice. And there's a further subsection that says that that section must not be read as determining that your own choice must be funded by the state. And we simply argued in Hines' case that the section which said that the Crown didn't have to pay referred to choice, and that failure to lack of constitutional right for payment did not affect an interpretation of fair trial, which in some circumstances would require counsel. As I recall, the Court of Appeal circumscribed in its decision fair trial, right to counsel, with the subsection in which the state are not obligated to pay. And at Privy Council, to my mind, if one looks at the decision of the Privy Council, what they're saying is that that section which says the state doesn't have to pay does not have an impact on fair trial. And there will be circumstances in which there must be funded counsel. However, that is covered by the Community Legal Services Act. And we're not going to say whether or not in Hines ought to have gotten it at the time because we don't have a full transcript of the trial. But we go on to say that perhaps the Court of Appeal were a little flippant because you have to take into account the defense counsel's position as opposed to the Crown's counsel's case in relation to whether you afford counsel or not. But in any event, we're going to send you packing for two reasons. We don't want to review the trial because you haven't put it before us. And secondly, we accept the point that if you succeeded in convincing us that he was entitled to a trial, it would automatically mean that his conviction was unsafe. And that amounts to a collateral attack. Which is some of the points that in other words, what the Privy Council were doing in Hines' case was equating a submission that you didn't have legal representation at the time. If you were entitled to it, if that submission succeeded, it would automatically mean that the conviction was unsafe. And I think they refer to the case of, I think it's Mohammed, in coming to that conclusion. And therefore, we can't grant the declaration because in effect it amounts to a collateral attack. And that is what I understood them to say. In relation to finally, my lords, in relation to the point that the learned director made on the additional evidence, he did not draw your lordship's attention, your honour's attention to the case of licorice, which is at tab 33 in volume 2, but I would do so simply for the reason that it is a case in which I think counsel at the Court of Appeal successfully argued for the admission of psychiatric evidence, even though it was available at the time, based on error of counsel. Yes? I think that is correct. In other words, the only excuse for not giving it was in effect, we're not leading it was the fact that ineptitude of counsel or not pursued or something like that. Though I have to say that in Licorice's case, there was far more evidence which would suggest that counsel ought to have pursued the psychiatric point.
The holding actually states there was evidence at the trial of the appellant's strange behavior at the material time,
yes,
and also the mental state that seemed troubled and unsettled.
Yes.
Of course, we don't have any evidence of that.
Any evidence of that in this case, except, Your Honours, that I say this. Any competent counsel, I think, if they were instructed that this statement was in fact voluntarily given, would of necessity, I think, explored the psychiatric. It was the only possible way of defending the case. If his instructions were that the statement was, because there was nothing else available. Nothing. In my view, Your Honours may know of Dr. Ramsey because he had the privilege of being Barbados's representative to the United Nations or something like that, and he is the gentleman who decided that he would claim diplomatic immunity for his dog when his dog bit his neighbor. And there's a lovely story, Your Honours will forgive me if I tell it, when the opposition joked to the then Prime Minister that they didn't understand why they didn't bring back Dr. Ramsey and leave the dog. Anyway, Your Honours, unless there's anything further I can be of assistance to you in reply, those are the submissions that I would wish to make on behalf of the applicant.
Very well, thank you.
As Your Honours please.
We reserve our decision and we'll give it on a date to be notified.
Thank you, Your Honour.
Much obliged, Lords.
All right.